Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within air for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. The court is open. Please be seated.
Good morning. Welcome to the Massachusetts Appeals Court on this Monday, June 3rd, 2024. I'm sorry for the delay in proceedings. This was Judge Milkey's last sitting, and so we were all there for the ceremony for that. We certainly wish him well in his retirement. I'm Justice Joseph Ditkoff. To my right is Justice Sabita Singh. To my left is Justice Christopher Hodgens, and we're the panel for all the cases today. As some of you know, in the appeals court, you have 15 minutes. There is no rebuttal. We have a clock there. It will start counting down the 15 minutes. When 90 seconds are left, the light will turn yellow. And then when time runs out, the light will turn red and we'll start counting up. If that happens, you can finish your sentence, but please don't say anything else unless you're answering questions from a judge, in which case, please complete your answer. I assure you we have read the briefs. We are familiar with the record, and so you're best off jumping right into your argument and not wasting time on background. With all that having been said, I'll call the first case, Commonwealth v. Gallagher, 23P726. I'll remind the parties that we're not going to use the names, either the first or the last of the victims. You can use initials or even better, mother, male child, female child, but certainly not names first or last. Counselor, whenever you're ready.
May it please the Court, Justices. My name is Attorney John Calcagney. I'm appearing on behalf of the appellant, Christopher Gallagher. I submit to each of you this morning that I believe the issue or the question to be answered on appeal is as follows. Is there a reasonable possibility that improper remarks by a prosecutor during closing arguments, which amount to the Golden Rule violation, may have contributed to a jury's guilty verdict in this case? I'd like to set the stage by pointing out what I believe to be undisputed facts. First, that there was in fact improper argument. During the closing remarks, the prosecutor, when addressing the crux of the trial, the credibility of the complaining witnesses, asked the jury to put themselves in the complainant's shoes. The Commonwealth concedes that the improper remark was made, both at trial and in its brief. Secondly, that there was in fact a timely objection, which was raised by trial counsel, interrupting the prosecutor's arguments. The issue was raised at sidebar, and the trial judge agreed that this was in fact highly objectionable. There was also a timely motion for mistrial made with the trial justice after the fact regarding this issue. It was timely preserved.
Counselor, I got the sense that there was a written motion for mistrial. Is that correct?
Your Honor, I knew that was going to come up today, and the answer to that question is yes. It was not included in the appendix. I was thinking last night that perhaps I should move the court for special cause to amend the appendix, but I did bring a written copy of it with me today.
Yeah, no need to amend the appendix, but we would like you to submit that motion for us.
We'll do that. I will do that by close of business today.
All right, great.
In any event, I believe that the law or the legal factors that the court has to consider when determining if prejudicial error occurred in this case is well settled. Those factors are laid out in the Nemec decision of the SJC as well as the Capella decision of the SJC, both of which are cited at page 21 on appellant's briefs. And the factors are as follows. One, was there a timely objection to the improper remark, which I just addressed moments ago, a factor clearly in the record and conceded by the Commonwealth.
Let me ask you about that, because I was a little surprised by the Commonwealth's concession on this point, because this doesn't really strike me as a golden rule type argument. I mean, isn't the golden rule designed to prevent prosecution from appealing to sympathy? This really wasn't an appeal to sympathy. This was more look at this from the victim's perspective, not in terms of what happened to her, but just explaining what she did. Isn't that different?
I disagree, Your Honor, respectfully, because in this particular case, the real issue for this jury was credibility. This was a case that involved two complaining witnesses, delayed complaints of indecent assault and battery, absolutely no corroboration whatsoever. One of these credibility cases where no one saw, heard, or ever suspected a thing. And part of the cross-examination of each of the complainants at trial was confronting them with prior inconsistent statements from the child advocacy or forensic interviews that each of them had participated in many years after the alleged incidents and, of course, years prior to the trial. And at the trial, both individual complainants testified inconsistently with their prior statements to authorities. And at this moment in time that brings us before the court, the so-called golden rule violation, the prosecutor was specifically addressing or beginning to address the inconsistencies in their testimony as brought out by the defense on cross-examination in an effort to get the jurors to sympathize with the complaining witnesses' inability to provide perhaps a more thorough, accurate, and truthful statement at initial disclosure. He was asking the jurors to place themselves in the complainant's shoes, and that is what led to that timely objection.
But even if that were so, when the judge gave an instruction saying you may not permit sympathy to affect your verdicts, wouldn't that tend to obviate any potential harm?
That's something for this court to analyze. I would submit to the court no in this particular case, and this is another one of the factors laid out by Capella and Nemec, was whether or not any specific or general instructions mitigated the error. There were no specific curative instructions in this case, and conceitedly the defense tactically didn't request one because we didn't want to draw any additional attention to the particular error. But with regard to the general instructions, the court simply followed the model district court criminal pattern jury instructions in the case, whereby the concept of sympathy not playing a role in deliberations is outlined. I will point out, because it may come up in the Commonwealth's remarks or perhaps questions that any of the justices may have, that the following day when we returned to the trial, the court had asked if we wanted any additional instructions read. One of the jurors had come back with a question asking to see the prior statement or transcript of the prior statement that was being used to impeach, which revealed that they were very interested in these inconsistencies, hence evidence of the actual prejudice sustained by Mr. Gallagher by the prosecutor's remarks. But in any event, the judge met with counsel and went through the pattern instructions and offered to reread any of them. The sympathy was one of the ones that was to be reread, and she essentially gave the defense a blank check. Are there any additional pattern instructions you'd like me to reread? And conceitedly, I did mention, why don't you go ahead and reread the defendant's right not to testify again, and let's reread the Commonwealth's burden of proof again. But those particular instructions were requested because of a burden-shifting issue that had come up in the Commonwealth's closing argument, something I didn't object to for tactical reasons. This is a collateral issue. There was massaging that took place between the appellant and the complaining witnesses in this case, and that massaging ultimately evolved into the alleged indecent touching. And as a part of the defense strategy, we conceded that the massages took place. They were witnessed by multiple people. There was nothing thought to be inappropriate about them. It was a course of dealing, if you will, between appellant and his then, quasi stepchildren. But in the prosecutor's closing arguments, he mentioned that there was, quote, no denial of the massages. And that comment, no denial, sort of imputed a message to the jury that defendant didn't testify. So I didn't make a big deal out of that, because during my cross-examination questions, you could infer that the defense conceded the massages took place, hence we weren't denying the massages took place. So when the judge gave us a blank check to add some additional model jury instructions, that is why those 2 additional instructions were read. But as the Commonwealth clearly points out in its brief and cites the transcript, I made it very clear on the record, I wasn't conceding that those added instructions or rereading of instructions that had been previously given in the final charge were any way, shape, or form a concession on our part that they were adequate to cure the error.
I
hope that addresses your question, Your Honor. I'm sorry.
I'd like to return to the question of whether the prosecutor's remark actually was a call to sympathy. I believe you had indicated that the issue had to do with details, included or not included, and that's what the prosecutor was addressing at that point in the argument, the Wendy's detail?
Correct.
Am I correct? All right. So if the defense is allowed to argue that the failure to include these details is a reason to discredit, it's a credibility contest, to discredit her testimony, why would it not be fair for the Commonwealth to argue that there are reasons that, aside from fabrication, that there are reasons that the details may be left out, and so that this is not an appeal to sympathy, but it's an appeal to common sense?
Having been a prosecutor, I think there was a more appropriate, less prejudicial way to do it. What you're referring to, Your Honor, can sometimes colloquially be referred to as fighting fire with fire. And I think the Commonwealth could have and should have said, members of the jury, the defense has pointed out inconsistencies between the in-court testimony of the complainants and what was said some years ago to forensic interviewers. But bear in mind the age at the time of the report. Bear in mind the stress or the emotions that the complainants may have been undergoing coming forward for the first time.
Isn't that essentially the same thing as, if you look at this from the victim's perspective, what the victim was going through at the time? Isn't that sort of a more summary fashion of exactly what you're stating?
Well, the law allows arguments to be made such that members of the jury look at this from the victim's perspective, because the jury is supposed to be a neutral and independent body in analyzing the evidence put before it, not necessarily to choose sides, but to make credibility determinations from, if possible, an objective standpoint. In this particular case, because of the way the prosecutor framed the question, he was asking the jurors to put themselves in the shoes of the particular complainants. And that's what makes it so objectionable. Not arguing or analyzing the differences in the testimony in court versus the out-of-court statements. Those inconsistencies were clearly brought out, and it was upon the prosecutor to make responding or rebutting arguments to try to bolster the credibility of their complainants. But it's the manner upon which they went about and did it that creates the prejudice. Does that answer your question?
Let me just ask you about the mistrial, the motion itself, because I'm a little puzzled by it. Mistakes happen all the time. That's why, one of the reasons why you have appellate courts, one of the reasons why we have trial court judges. The trial court judge can remedy a mistake if it occurs. Why did this rise to the level of a mistrial? Why wouldn't it just be a matter of the judge addressing this with an appropriate instruction?
Mistakes do happen all the time, and objections and sometimes curing instructions address them on the spot, and the trial moves on. But some mistakes are so fundamental that they undermine the overall fairness of the trial process. And prosecutors have a duty to uphold the law and to do justice regardless of the outcome of the case or the verdict that's delivered. But if a prosecutor, in the methods or means of his or her advocacy, subverts the rules or goes outside the bounds of fundamental fairness, those particular types of mistakes justify a manifest necessity to declare a mistrial. The argument or the understanding here being that the mistake was so fundamental and so severe that there's no way to cure it. Thereby, a mistrial is necessary to start fresh with a group of jurors that that were not exposed to the prejudicial remarks. And that was the purpose of the mistrial, to ask the court to give essentially Mr. Gallagher another trial with a new set of jurors that hadn't been asked to place themselves in the shoes of the complainants. As we revisit the CAPEA and the anemic factors, we've talked about so many of them just in our discussions here, but one of the issues, and the Commonwealth raises it in its memo, is whether or not the prosecutor's improper remark went to a central issue in the case or a collateral issue. And an interrelated factor is whether or not the overall evidence against the defendant, in this case Mr. Gallagher, was overwhelming. I pointed out at the beginning of my remarks that this was a credibility case. The entire prosecution rose or fell based upon the jury's decision to believe or disbelieve the complaining witnesses. That was the only issue in the case. So I don't think it's accurate for the Commonwealth to try to couch this as a collateral issue. I suggest to the court that it was the central issue in the case. And when you consider the fact that the credibility was the central issue in the case and that the jurors came back with a question asking about that prior inconsistent statement, it's clear to the appellant that the prosecutor's comment was in fact effective, drew the jurors and captured the jurors' attention. And it's for those reasons we think Mr. Gallagher sustained prejudicial error, and it's for those reasons we believe his appeal should be granted.
Thank you, Counselor. It's a rare treat to get the trial in a criminal case. It's a rare treat in a criminal case to get the trial lawyer arguing in front of us. You tried a great case.
Thank you, Your Honor.
We'll hear from the Commonwealth now.
Yes. Good morning, Your Honors. My name is Rob Kidd. I represent the Commonwealth in this matter. I am standing in for the person who wrote the brief. She is no longer with our office, Julianne Campbell. But I'd like to start just by stating what the standard is, and we are still dealing with an abuse of discretion standard here. And it is well within the judge's discretion, as you know, to deny a motion for new trial. And the law talks about a clear, if she makes a clear error in judgment in weighing the factors for granting a new trial, and that situation, you know, that's when a reversal of her decision might be warranted. And she's doing that with a range of reasonable alternatives, as the case law talks about. So the question here is whether this judge, exercising her discretion within the range of reasonable alternatives, abused her discretion. So what are those alternatives? The alternatives are she could have allowed the motion for new trial. She could have stricken the specific testimony at issue, which counsel specifically said that he declined to do because of a strategic reason, not to bring attention to it, which I understand, having been on that side for many years. And the third thing, so in this particular case, she also could have re-instructed, and that's what she did. She also could have cured that error through curative instructions. And there was a detailed sidebar, a fairly lengthy sidebar with the two attorneys. And counsel here specifically requested a number of instructions, one of them including sympathy, the other one including the burden of proof, the other one that the defendant doesn't need to testify, and that closings are not evidence. He added all those requests to the instructions. He did not request he did not request the judge to strike the testimony in any way, nor did he ask the judge to give the instruction when it happened, or any kind of instruction when the comment occurred. So, exercising her discretion here, I suggest she was going with the attorneys. This attorney also said after the discussion, he said, I think that will cure any burden shifting. And that was in the transcript. That's on our brief at page 13, and it's in the transcript at transcript volume 4, page 11.
Sure, the burden shifting, but not the golden rule problem, right?
Well, I think that's what I gather is that the defense counsel's argument is primarily based on burden shifting. It's all sympathy as well. I would like to take a moment to read the actual testimony to the court, the testimony that led up to the comment. And just so your honors remember, what happened was counsel in his closing had attacked the credibility of the victim and the complaining witness, who were apparently lifelong they were teenage friends and knew each other quite well, best friends. And he accused the two of colluding and coming to court and coming up with this Wendy's thing, or yeah, it was Wendy's, this whole disclosure with Wendy's. And they both came into court and they both mentioned the Wendy's incident. And he said to the jury, you know, they never said that to the authorities, and they come in here both together today. You could infer they're concluding. And in response to that, and as the court knows, the Commonwealth is entitled to respond to attacks of the credibility of our witnesses in our closing. And the prosecutor says, we're talking about an inconsistency. Oh, they went to Wendy's, okay. Well, the first time that she ever told anybody in authority about this case, do you think her primary focus was on the fact that they went to Wendy's first? It's an inconsequential fact that we're making mountains out of. I'd ask you to use your common sense. If that happened to you when somebody asked you for the very first time to talk arguably about what might have been the worst day of your life, then counsel very swiftly and competently objects. So I think that the jury, what the jury got the gist of there was not that we're trying to get some sympathy for the victim. We're just trying to show that any rational person, especially a child who's suffering from these, terrible, events. If you have a traumatic event, you're not going to remember that you, for example, went to Wendy's and told your friend. That's all that he conveyed to the jury, and I think they got that. And if you read it very carefully, he never finished the sentence.
You think she forgot about Wendy's?
I'm sorry?
You think she forgot about Wendy's?
I think it's possible. Oh yeah, I think it's very possible. Yes. Yes, I think that she was asked by the police what happened. She gives a statement to the police, and she just tells them, I assume, I didn't read the statement, but I assume that she tells them that she told her friend about the events, describes that statement to her friend. I don't know that it would occur to her or anyone, frankly, to say when and where and how it occurred. I guess maybe it would, but it certainly was not an unreasonable argument for the prosecutor to make. And like I said, if you read it carefully, he never finishes the sentence. He never tells the jury what they should do. He says, if that happened to you, and then he's cut off. I view this as a very, very, very de minimis misstep, if at all. I'd like to point out to the court the case of Commonwealth versus Witkowski, which is in both briefs. And this is a case where they found that a particular comment was not prejudicial. I have it here on the computer, if I have a second.
While you're pulling that up, let me just ask you this question, because when I first read this argument, I was struck by the fact that, first of all, by the fact that defense counsel interrupted the argument. It didn't seem to merit an interruption. And then I was struck by the fact that as I had said earlier, this didn't strike me as a golden rule violation. But what surprises me even more is that the Commonwealth now seems to be conceding that it is a violation.
Well, that's what I was getting to, and I did not write the brief, and everybody has a different take on things. I personally don't believe that is the case, and I think this is what Witkowski says. Obviously, the court can do whatever it wants. It's not bound by any concessions on either side if it sees the law. In Witkowski, I would just read this. This is a homicide trial, apparently, and
Yes, it was a homicide trial.
Yeah. So in Witkowski, during the argument, the prosecutor repeatedly urged the jury to, quote, think about the time immediately before the victim's death, including that she knew exactly what was going to happen next. With respect to the length of time it took to the victim to die by suffocation, he pointed to the minute the medical examiner had testified that it would have taken the victim to die, with her nose and mouth covered, and urged the jury to think about a minute of gasping for air, wondering if you're going to live or die, and at some point knowing you are going to die. After apparently pausing for 45 seconds to illustrate the length of time, the prosecutor explained that it was, quote, more important to know that the victim felt fear and terror at the hands of her rapist killer because the Commonwealth was pursuing a conviction on the theory of extreme atrocity or cruelty. The court found that was not prosecutorial misconduct, that was not stepping over the line. The court said,
I'm not sure I understand why that's relevant here. This isn't an extreme atrocity, indecent assault and battery case where the jury has to figure out what the victim experienced emotionally.
well, I think the problem is stepping into the victim's mind. I think it's extreme atrocity and cruelty is about pain that's inflicted upon the victim. And here he's trying to get them to put themselves in the victim's shoes, and it's a very emotional appeal if you read it. I think it's an extremely emotional appeal in the words that he put it. Here we're talking about a comment that didn't even get made. It was interrupted by defense counsel, and it didn't even finish his thought. And in the context of that I just read to you, I think that any reasonable juror would not have taken that as, feel sorry for this poor victim. Any reasonable juror would have thought that the prosecutor's just trying to make the point, hey, she could have, and anybody could have forgotten this in those stressful circumstances. Maybe the jury didn't buy that. Maybe some on the panel doesn't buy that argument, but it doesn't change the fact that the jury would not have understood this as some role of stepping into the victim's shoes and having sympathy for the victim. I don't see that at all, and we made that point in our brief. So, yeah, I don't know if there's anything else I need to say unless there's questions.
No.
Big fan of less is more, always.
Thank you much. Thank you both.
Thank you.
Well argued. Second case is Commonwealth versus Alamonti, number 23P666. No rush, whenever you're ready.
Hi, good morning. May it please the court, and Jennifer Cox appearing on behalf of Christopher Alamonti. Mr. Alamonti is appealing of a conviction of larceny by false pretenses after a bench trial in Salem District Court. And on appeal, we raised two issues, one challenging the sufficiency of the evidence, and the second challenging the amount of restitution ordered. So for the first issue, he argues that the court erred in denying his motions for a required finding of not guilty. And where this case involves a promise to perform future conduct, the Commonwealth is required to prove that at the time that the defendant promised the homeowners that he would build the pool house and that he accepted the deposit checks, that at that time he did so with the intent of never performing the job. And so here we argue that even when considered in the light most favorable to the Commonwealth, as is required, that the evidence fell short. And to be sure, the Commonwealth's evidence certainly included facts that are unflattering to the defendant and his business practices. But the question here is not, whether he was someone that you would hire as a contractor, knowing these facts. It's whether this evidence is indicative of his intent to not ever build the pool house.
Saying he could have been lying about being
Exactly.
insured, licensed, and he could have been lying about the fact that he'd get to work on it immediately, and he could still have intended to
Eventually
accomplish
build
the
the
work.
pool. Yeah, exactly. That is exactly the point.
Why would those inferences be the natural ones to take away from those kinds of misrepresentation?
So yes, it is under the light most favorable to the Commonwealth, but here, where you look at how those particular facts operated here, so for example, his misrepresentation about being a licensed and insured contractor, in fact, did not. He was correct that his lack of those things would not impede his ability to obtain the permit, which he did just a couple weeks after the contract was signed. And the contracts, as you can see in the appendix, specifically includes building the pool house on it. And the other factor about that he said that he would begin immediately. The start date is not included in the contract. The bane of every attorney involved is when parties don't include these details in here, and then what do we do with them? But also, the use of the word immediately, as he explained to the homeowners later, was that he couldn't begin the work until he obtained the permit for it. So, his use of the word immediately, is inartful and perhaps a misrepresentation, but it also could have just meant immediately when I get the permit here.
So how long was it? I mean, the pool was never built, or the
Correct.
pool house?
Yes.
Never built.
Right. So
Not by him. Someone else built it, right?
Correct. Yeah, right. He never built the pool house, but after the parties parted ways in April, sometime after that, the pool house was built. Correct. But yes, he never.
Sorry to interrupt. I just wanted
Yeah.
to make sure I didn't have that
Correct.
wrong.
Yes. Eventually, they did get a pool house, but not through Mr. Alamonti.
So
yes.
how long was it from the time of the contracting to the time of, them sort of leaving the job?
So it's November 24th is when they signed the contract, which is a Friday. November 27th is Monday. That's when the homeowners call and say, when are you going to start? It's December 10th is when they have a conversation where he says, I'm trying to obtain the permit. I haven't been able to get it yet. How about I begin on the interior work that is also part of this deal. So he begins the work, and then it's December 19th that he gets the permit that includes the pool house work on it. So it's from November 24th, the contract signing, to December 19th, when the permit is obtained.
He doesn't start on December 19th.
Correct, but that's when he obtains a permit that includes the pool house work on it. So he was able to successfully get a permit that would have allowed him to build the pool house.
So was there a reason given for it not having been built after that?
The parties discussed that the weather had turned, he said that the weather had turned and that he would not be able to pour the concrete footings at that time for that. And they do have discussions about the weather, so everyone seems to be on the same page that, this being late November, early December, at some point we're going to run into issues on the weather being an issue. But he did seem to represent the weather is good right now for the next couple days. I should be able to get started. But then he reports, a couple days later, I'm having trouble getting the permit for that, and I can't begin until I obtain the permit. And again, the issue is whether these are indicative of his intent to perform the contract at the time that he entered the contract. And
When did they wind up firing him?
I'm sorry, could you
When
repeat
did they
that?
wind up firing him?
April 10th, I believe, is the last day he's on premises.
He hadn't done anything on the pool by then.
Correct. He did, at no time did he do any work on the pool house. He says in his testimony that he ordered supplies for it. The judge sitting as fact finder certainly is free to disregard that, and he is cross-examined about, do you have any receipts for that? Did materials ever appear? And he, concedes that no, he does not have any receipts for that, so that's correct. So
There was discussion, though, about breaking ground before the cold weather set in,
yes.
which makes sense at that time of year. And then the defendant takes off to Florida on a prearranged trip. So why couldn't the judge infer from that he had no intention of breaking ground before the cold weather set in?
Well, I think given all of the circumstances that happened at that time, yes, he went to Florida, the day after that they signed the contract for this trip. He's gone only a few days. The weather, I don't know that there's testimony about, he can't guarantee the weather is going to be good for a period of time. Did it come across that he was guaranteeing, I checked the weather and it's going to be good? Maybe, but, I don't know that that's reasonable for the homeowners to rely on his prediction of that. There's also no testimony that they would have gone with a different contractor had he not been able to start immediately, and they seem satisfied eventually when they talk about, okay, well, we'll do this in the spring when the ground thaws out then.
But the judge seemed very moved by the fact that that chain of events, in that it seemed to be sort of a mechanism to get, for the defendant to get his hands on the more lucrative contract of doing the work inside the house. So that, she seemed to accept that theory that, well, he had no intention of building this pool house when he promised to build it. His real aim was just to get into that house and start working on it in December, which is what happened.
Right, and that is what the judge discussed, and I would say two things in response to that. One is, I think it's noteworthy that he immediately only deposits one of the checks. You know, if this is a fraud and he's intending to never build the pool house, he is given $15,000 and he only deposits $9,000 of it. He does not deposit the $6,000 until after the building permit is obtained. So again, as we're looking at his intent at that period of time, this isn't a case where he, absconded with all the money and then never comes back. He deposited half of it, and it was, as the judge remarked, it's appropriate for him to deposit the deposit check, so that, in itself is not a red flag, but also the fact that he only deposited one of the checks, I think is a large factor in consideration of his intent.
I'm not sure I follow the logic of that. If it's a deposit, it's a deposit. He'd be entitled to deposit. What does that show?
I think it shows as far as if
why would he just do half? Why would he just deposit half of it rather than,
I'm sorry, are you asking why from his perspective did he do? Okay, so he explained it that he needed to deposit the $9,000 in order to order the pool supplies to be put on, he explained that they needed to be pre-ordered, the cement and that, because the cement business apparently slows down in the winter for that. So that's his explanation for why he only cashed one of the checks. The other one is cashed at the same time that he gets the permit for the work. And at that time also, there's in the appendix where the permit is included in there, and as the judge remarked, we also see on that the permit itself costs $2,221. So I think the $6,000 was deposited at the time then because it was needed to obtain the permit as well. So did that answer your question?
I understand that testimony,
Okay.
but if it was a deposit, then he would have been within his rights to
Yes.
deposit all of it anyway.
Right, that is what I'm saying, is that it was within his rights to deposit all of it. And the fact that he didn't, I think, speaks to that he did not have an intent to never do the pool work. Because I think, in most cases that I deal with as a defense attorney, you take all the money and you run off to Florida. You don't take part of it and then, keep coming back and answer calls on Monday and say, oh, I'm not there. And then, on December 10th, how about I start on the interior work? And my other point in response to you, Justice Hodgens, that I forgot about was also that as the parties testified, the homeowners both testified, the work to do the interior of the house was expected at all of the same time. That this was part of the discussions at the time of the signing of the contract, even though the contract, if you look at it, seems to only detail the pool work, except there's 2 garage doors included on there and a roof, which I'm not sure if the testimony is not helpful on this as to whether that was part of the pool house or whether that was part of the housework that was done. But anyway, he didn't, to the extent that the judge said that this was, a ruse, and then once they offered him more work, he said, oh, I guess I'll do that and I'll get, the $115,000 that they eventually did pay him. I think that doesn't make sense here where it's not factually supported here where the homeowners as well testified, no, we were retaining him to do all of the work at that time. So he already knew he was going to do that work, so he didn't need to use this as a ruse to kick off this series of events.
Could you address the restitution issue?
Yes. So for the restitution, the court ordered the whole $15,000 in restitution. And I think from the court's remarks, we can discern that the court's justification for that was $15,000 was the amount that the homeowners parted with in response to his misrepresentations. But, as the court is aware, the case law is clear that the purpose of restitution is not to satisfy a victim. It is to compensate for their actual economic loss. And so here, I think the evidence is clear that the actual amount of loss was $9,000, not $15,000. And this is just, one part of my argument.
That assumes that they got $6,000 worth of good interior work. But wasn't there quite a bit of testimony that the interior work was substandard and they had to pay $17,000 to actually get it fixed after they fired your client.
Well, I would disagree that it means they got $6,000 worth of good work. I don't think the law requires that. I think they just had to get a value of $6,000 out of it. And again,
But did they get $6,000 value added? It looks like they might have actually lost another $17,000.
Well, they certainly had, 2,221 of that went to the permit, which was used, so that's, 2,000 of value after that. He installed, he did all the demolition work, he installed a country and western themed bar, an ice cream parlor, redid stairs. There was, I think, certainly more than $6,000 worth of work done, and I think the homeowners themselves testified to that it was their understanding the $6,000 was rolled over into that work. And I would say this is the best evidence, in my opinion, of this is in the contract of April 3rd, which is drafted by the homeowners. And in that, she says, she wrote a note in there that says, sorry, I want to get the wording right, and I can't put my finger on it. So, on November 24th, 2017, check 114 in the amount of $9,000 was given to you as a deposit to begin construction on the pool cabana. This work has not been done as of April 3rd, 2018. So the parties' understanding across the board was that the $9,000 was what was earmarked for the pool, that they did get the value, pool house, that they did get the value of $6,000 deposit in the permit and in other work that was done over the ensuing 5 months. And, it's their testimony as well in addition to this contract. So I think where the evidence is all in accord that it was $9,000 was the pool house expense. And to that, I would also note that it seems to be that was the Commonwealth's expectation as well. When they, the verdict came in and they moved for sentencing, they asked for $9,000, and it's the judge that says, well, isn't it 15? And the prosecutor.
But is restitution limited to sort of the out-of-pocket loss to the victim? I mean, if we go with the judge's theory that pool house contract was just a means to get at this larger contract for the interior renovations, can't the judge say, well, as part of the restitution, we're going to disgorge some of the profits that you obtain from that interior renovation? That's part of the injury here.
I think that the judge could have done that, but I think, it definitely is the Commonwealth bears the burden of proof on the amount. And the case law is clear that this can't be just an amount that the court comes up with. There's the case, it's one of the ones cited in the brief, but I'm drawing a blank. I think Dehaney, something like Danahy, where glasses were damaged and the court, did a guesstimate of what the cost of glasses were, and the appeals court reversed that and said, we understand your intent here, but we can't just have estimates. This has to come in as evidence in some manner. So here, I think perhaps that could have been done if the Commonwealth had introduced evidence to show here's a specific value of work that was given as part of this initial deposit and not performed. I think you're correct that could have happened, but here it didn't happen. So I think the judge was not at liberty to just sort of try to, split the baby, as it were, and give more money to it. Although I do agree that I think the case law about restitution does say, we do try to fully compensate. We're not trying to nickel and dime a victim's actual economic loss incurred, but it does need to be actual. So I see that my red light is flashing if there are no other questions. Thank you.
Thank you, Counselor. We'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning. May it please the Court, Marina Moriarty on behalf of the Commonwealth. This court should affirm the defendant's convictions where the evidence was sufficient to prove larceny by false pretenses. Respectfully, Your Honors, the defendant's arguments here today are all trial arguments. But this court, viewing the evidence in the light most favorable to the Commonwealth and resolving all reasonable inferences in the Commonwealth's favor, as it must, there was overwhelming evidence to demonstrate that the defendant had no intent to complete the pool house. We're not talking about the inside work. We're talking about the pool house at the time that he entered into an agreement. The defendant made false representation as to his status as a contractor, licensed contractor. He made false representations as to his status as an insured and licensed contractor. He made false representations that he would be able to complete the project immediately. There was no caveats about, well, I need to get a permit, and once I get a permit, I can start the project soon. There was no permitting discussions that were presented to the homeowners in this case. based upon the false representations of the defendant, the victims in this case signed over 2 checks worth $15,000 for the pool house. The agreement of the interior work was not part of their agreement, and the larceny was complete at the time the $15,000 was passed over to the defendant.
But that's one of the difficulties with this case. This isn't a case where some money was taken and the guy takes off. That he was working.
But
I know it wasn't that, but that's a timing issue because it's not appropriate because of the weather to be doing that work. So it's an unusual case that he remains and actually does do work. It's just other work. And when the weather in April, that might have been the time when the weather changed and it was time to do the pool work after all the interior work was done.
I think this court needs to look at and according to the case law, larceny by false pretenses looks at the time the agreement was made, looks for a false statement of material fact, whether the defendant knew or believed the statement of false when it was made, and the defendant intended the person to rely on the statement, and the person in fact relied on the statement and turned over the check. So what happens after goes to what his intent was at the time the contract was signed. And in this case, obviously intent is very often not proved by direct evidence, but by circumstantial evidence and inferences. And in this case, the judge, who was the fact finder, reasonably concluded that the false statements at the beginning and the fact that the defendant continued to draw out his relationship with these victims and in fact continued to benefit from his original crime was evidence of the fact that he never intended the pool. The pool supplies never showed up. But again, the pivotal point is at the time that the victims parted with their money. That's when the crime is complete.
But you're asking us to find that this defendant wants to rob them on the pool contract, but wants to satisfy the interior contract. How do we get there?
There was no contract. There was no discussion. There was some vague discussions about interior work. But if you look at
He signs an interior contract and performs it.
Subsequent to the pool contract. The pool contract is what gets him into the door with these victims. And again, there's additional consciousness of guilt evidence. Maybe he's trying to make it right, but again, the crime is already completed. He later applies for a license. When he does eventually get the permit, he uses a different company name because he knows that he's not licensed, he's not insured, he's not permitted to get the permit from the city. So he uses a different company to get the permit and then doesn't go back to the victims and ask them to sign their names. He forges their signature on this city document.
Those are all crimes, but they're crimes aimed at doing the work.
But had the crimes happened before he signed the paperwork, before he accepted the money, before the victims parted with their money, then maybe the larceny by false pretenses would never have materialized. It materialized when he made false representations and the victims relied on the false representations. It's in accordance with the
Are you challenging the idea that the defendant had to intend not to perform the contract in order to have committed the crime?
No, I'm saying exactly that. He had to not intend to perform the pool work when he signed the contract. And the fact that he lied and then said I would perform it immediately, and then he went to Florida immediately. He testified himself that he had this pre-planned trip to Florida. So again, there may be other inferences that could be made. The defendant could have been trying to fix the situation, but the point is that the trial judge in this case, the fact finder, was reasonable in her findings, in the inferences that she drew based on the evidence that this defendant had no intent to complete the pool project under the conditions of that contract at the time that the victims turned over their money. And again, I would just emphasize that the interior work was not part of the deal. And this goes to the restitution issue. The issue of restitution is restitution for the crime. What's the crime? The larceny by false pretenses. How much did the victims lose by larceny by false pretenses? The evidence is undisputed. The victims gave the defendant $15,000. The evidence is also undisputed that these victims would not be getting some sort of unjust gains by having been victimized by this crime if they were to get the $15,000 back, because they ultimately ended up spending over $22,000 on a pool house. So had the defendant...
So, all right, so that's very interesting, because does that tend to support what the judge found here, that the pool house contract was really merely just a mechanism? Basically, you underbid the pool house contract with an eye towards getting into the house and doing the interior renovations, and then at some point, you're able to just make up the difference as you're doing the work in the house.
I think that is a fair inference, that this defendant, what they ultimately ended up paying was significantly more than what this defendant had bid the contract at, which again goes to support the idea that this defendant had no intent to build this contract.
I thought they testified that it only cost $20,472 to finish the pool house.
I'm sorry, Judge, I had in my head $22,000, but I can't...
$22,000 is the contract that the defendant signed, but I thought they testified that it actually cost less to do the pool house with a presumably competent licensed contractor.
My memory is that it cost significantly more to complete the pool house using another licensed contractor. And I don't think there was any testimony about whether they had to pull a new permit or whether the old permit was simply, not effective anymore because it would have been under a different general contractor. So again, I think that the Commonwealth may have asked for a different amount, but the judge was certainly within her discretion based on the evidence to order a full $15,000 worth of restitution. And if the court has no further questions, I'm happy to rest on my brief.
All right, thank you both.
Thank you, Your Honor.
Well briefed, well argued. All right, we will turn to our third case, Commonwealth versus Moore, number 23P857. Whenever you're ready, Counselor.
Good morning. May it please the court. Lindsay Cantor on behalf of Derek Moore. Serious errors occurred at every stage of this trial, even beyond the final instruction. Those errors created a snowball of prejudice that picked up speed and got bigger as it rolled downhill. The testimony of both witnesses was rife with first complaint errors. We have multiple complaint evidence, testimony about the investigation in this case, including a report by a mandated reporter to DCF that creates an imprimatur of official belief. We have a failure to give a first complaint instruction at the time the complaining witness testifies about her complaint. And we have Tanya Anderson's testimony about her professional qualifications that gave her the veneer of an expert, thus bolstering the credibility of her testimony as well as her belief, her implicit belief in the complainant's credibility. We move on to the Commonwealth's closing, where there were grievously improper remarks. An inflammatory remark that implied far more serious sexual abuse than what was alleged by this complainant, and a comment about delayed disclosure that required expert testimony. There was none in this case. The question that the jury asked regarding whether there was a possibility that AA would end up back in Mr. Moore's care revealed the impact of the prejudice of all of these errors, that it was considering an extraneous factor.
I don't understand why that's extraneous. The question is there a possibility the victim will be back in Derek Moore's care, and is victim aware of that? Considering that the whole theory of the defense was that she's lying so she won't have to go back to Derek Moore at the time, wasn't it reasonable to wonder as a jury, is she lying now? because she's afraid of going back to Derek Moore. It's the is aware that reveals the jury's thinking. How do we determine whether she's lying now? Why isn't that proper thing to think about?
Her motive to lie at the time of trial is a proper consideration for the jury. But this is a multi-part question. And the first part of that question is there a possibility that she will end up back in Derek Moore's care? Her awareness of the answer to that question certainly goes to her motivation. But whether there's a chance she'll end up back in his care is an impermissible factor for the jury to consider. For this, we have to look at the other errors in the case. The way that this case was tried, both the Commonwealth's theory and the defense, which was that this was a neglected, parentified child who lied in order to stay in a home where she felt safe and comfortable, maybe for the first time or the second time in her life. That was the context of this trial. And then the prosecutor's inflammatory remark, inflamed the jury's sympathy for AA. So the jury goes back into that jury room, and they're thinking about, understandably, I would submit, they're understandably sympathetic to this neglected parentified child. Both the prosecution and the defense were sympathetic to this child in different ways. They're sympathetic to this child. They want to protect her. And the first part of that question, is there a possibility she might end up back in Derek Moore's care, reflects their thinking that they want to protect her from that. An important factor to remember here is that the jury reported initially that it was evenly split. This was not a jury that went in thinking the evidence is overwhelming. We have insight that at least 3 jurors back in that room were initially not convinced that the Commonwealth had proven its case beyond a reasonable doubt.
So you're suggesting that the mere question posed by the jury is indicative of an error on the part of the jurors?
The question gives
In other words, you're not just taking issue with the judge's response to the question. You're taking issue with the very fact that the jurors came up with this question in the first place.
No, Your Honor. I am taking issue with the judge's response. The fact that the jurors came up with this question in the first place was a reflection of both the theory of the case and of all of these prejudicial errors that occurred while the case was being tried. The error is in the judge's response. Now, it is quite clear from the case law that if there is an implication that the jury may be considering an extraneous factor, and I would submit, even if there's, to your question, Justice Ditkoff, even if there's some ambiguity about the impact of this question, that it certainly reveals the jury may have been considering.
Does it make sense for the judge to say, you can consider whether the victim is afraid of returning to the care, but you can't consider whether she actually will return to the care? Is that really a meaningful thing to say to a jury?
I would submit that wouldn't have been the appropriate instruction in this case. There were several different interventions the court could have taken, and the case law makes clear that intervention of some form is required. So I would submit that the appropriate, if the court was going to choose a strong admonishment or a curative as its intervention, the appropriate thing would be to say simply that the jury must not consider AA's future custody status in making its determination about Mr. Moore's guilt or innocence. An admonishment not to consider that. The judge could have been silent about whether it could consider her own beliefs or motivations.
How can he do that when that's the gist of their question? Is she aware of that? How can the judge ignore that and suggest that they shouldn't consider that, which is a key thing in the case?
Her motive to lie is a proper consideration for the court, but whose custody she's going to be in is not. So what the judge had to do was disabuse the jury of the notion that it could consider where she might end up. Because what the jury, at least there is an implication that the jury was asking whether their decision to convict or to acquit would impact where she would end up, in whose custody she would end up. there was an implication that they were considering acting to protect her rather than based on whether the Commonwealth had proven its case. And so that part of the question, the judge had an affirmative obligation to redirect, either by providing a direct answer, providing a strong curative, conducting individual voir dire to try to get at what was going on. I would suggest a curative would be more appropriate in this particular extraneous influence case than voir dire. But the case law is clear the judge had to do something. And in a case like Torres, in a case like Goldman, you see these mixed questions where a part of the question reveals consideration of an improper factor, or where an interpretation of the question reveals that. And as was the case in Torres, the question also got at motive to lie. So just because the question also gets at motive to lie doesn't mean that the extraneous factor does not need to be redirected by the court.
But isn't there some advantage here, especially where defense counsel was satisfied with what the judge did? So isn't there some advantage here to the defense of just, let's leave well enough alone because someone on that jury is entertaining some doubts here, so let's not, answer this question directly. Let's just let that doubt kind of, permeate the jury and come back with an acquittal or a hung jury. Isn't that a possibility?
I do not see this as a reasonable strategic decision on the part of the defense. Certainly, it affects the standard of review, or arguing this is an abuse of discretion standard of review, but the defense counsel, in his closing, implored the jury not to consider AA's future custody in this case. Defense counsel was, I would submit, concerned that the jury might consider that, given all of this evidence that they had heard and given the appeal to sympathy in the prosecutor's closing, which came later. Defense counsel was concerned about that and actually attempted to get ahead of it by imploring the jury not to consider her future custody. Then the question revealed that the jury was doing just that. Now, do I wish defense counsel had objected? Of course, it would be preferable if defense counsel had objected at that point, but that's why we have standard of review, we have this substantial risk standard for waived errors. The court should have redirected that speculation. I'd like to talk about Tanya Anderson's testimony. Tanya Anderson was ostensibly the first complaint witness in this case. She was there to testify about AA's initial allegations, and she did so. She also testified permissibly to a little bit of background information about that she was AA's foster parent, how she had come to be in her life. But her testimony also contained extraneous information, a bunch of statements about her own professional qualifications, about AA's mental health diagnoses, that gave her the veneer of an expert. That caused prejudice by bolstering her credibility and thus AA's credibility. When Tanya Anderson testified that not only was she a foster parent with 10 years of experience who had fostered 25 children, but that she had undergone rigorous training to become a specialized foster parent for children with severe trauma history. She testified she was a mental health specialist who had been practicing for 25 years, that she was a mandated reporter, and that she was at the time an agent of the government sitting on the Boston City Council. She did all of that, and then she went on to testify, over objection, to AA's mental health diagnoses, that she was autistic, that she had attention deficit hyperactivity disorder, that she was distractible, that people could become lost in conversation if they didn't have specialized training in dealing with children with those diagnoses. She testified that AA was sad, that she was so worried about her that she put up cameras. She testified that AA had post-traumatic stress disorder. So she held herself out as an expert on severely traumatized children, and then in essence testified that AA was one of those children. Her implicit belief in the truthfulness of AA's allegations must have carried great weight with the jury.
She was not permitted to testify in her belief.
She did not testify directly to her belief, but when you look at cases such as Lopez and Pereira, as well as the cases establishing why a mandated reporter is not permitted to talk about making a mandated report to DCFs, that's cases like Stuckish, Haggett, Velasquez. When you look at those cases, what they reveal is that when a first complaint witness testifies to being a mandated reporter, to making a mandated report, or testify or acquires this veneer of an expert and then testifies to the first complaint, all of those cases talk about the imprimatur of official belief that in the complaint.
I mean, that's what
that
Pereira
gives.
says. It's an old case, but I don't really get it because being a mandated reporter actually goes the other way. Even if you don't believe the accusation, you have to report it, as opposed to a non-mandated reporter who probably wouldn't tell the police unless they thought it was true. I don't get why being a mandated reporter doesn't actually decrease the likelihood that the jury would think that you believed.
Your Honor, I'd respectfully push back on that because that is exactly what we see in Stuckish, the case that established the doctrine of imprimatur of official belief, and then in Haggett and Velasquez. In each of those cases, the example given of the kind of official investigation testimony that gave an imprimatur of official belief in the complaint is a mandated reporter making that mandated report to DCF, or at the time to DSS. So those cases establishing that doctrine and reiterating that doctrine all talk about the imprimatur of official belief from a mandated reporter.
Considering that the defendant, in his opening, told the jury that it was reported to the authorities, didn't that allow the Commonwealth to explain how it got reported to the authorities?
The fact that defense counsel made a generalized statement that this had been reported to authorities does not in any way open the door to the type of detail that was provided, all of which came out on direct examination of the complainant and of Ms. Anderson. So this type of, again, this level of detail went far beyond one general statement that there had been a report. The defense counsel said that in the context of talking about potential inconsistencies in testimony, not in the context of actually discussing the process or the content of any of those additional complaints. And I see I'm nearing the end of my time. In assessing prejudice in this case, this court should look to cases like Cruz and Fredette, Montero, Velasquez, Durgo, and Vasquez, all of which have combinations of errors that are similar to the combination of errors in this case. They all analyze it under a substantial risk standard or under a mixed standard of review and determine that those errors created a substantial risk of miscarriage of justice. That's exactly what happened here. I ask you to reverse Mr. Moore's convictions. Thank you.
Thank you very much, Counselor. We'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning. May it please the court. Darcy Jordan on behalf of the Commonwealth. We're asking to affirm these convictions of the indecent assault and battery of this child victim. And if I could just start from the overreaching complaint that defendant here lodges on appeal. They are basically claiming that there's evidentiary errors here and claiming that evidence was improperly admitted. But the real gravamen of the complaint is really the tactical decisions made by defense counsel. And that kind of argument is really more appropriate in effective assistance of counsel claim, which we do not have here. We do not have an motion for a new trial. So I suggest all the evidence that we are now talking about and challenging, none of it was objected to. It's not objected to because it all fell into the theory of the defendant's case that this victim was fabricating when she initially disclosed in between, and she was fabricating to this jury. And I essentially think if we look at the defendant's defense counsel's opening, that's his argument. His argument is as soon as the victim hears that the defendant might have visitation, she says, oh, actually, he abused me. And the defense counsel argues in opening is that then she talks to her grandma, she talks to DCF, she talks to, and now she's going to lie to you. She lied to all of them, and now she's going to lie to you.
Defendant mentioning grandma in the opening, did he?
I think so. I'm happy to talk about grandma. So I think my whole point is, as we talk about the evidence here, the closing, and even the question, I think it's important to understand that none of these things were objected to. We're looking at this substantial miscarriage of justice, and I do not think the defendant can prove any of the claims here, because all of that evidence and all of those decisions all fell into the theory that the defendant was exposing. And frankly, if the defense attorney had objected to some of this evidence, he would have no theory. He would not be left with that. So I'm happy to talk about maybe each of the evidence in turn, or I know the court focused on the jury question, but I do want to point out there's allegation the first complaint was violated with the grandmother's testimony, with mom's testimony, and this allegation that there is pressing charges. If I could just talk about mom's testimony. Mom's testimony is not the first violation of the first complaint, because the victim testifies, I told my mom and she didn't believe me. So to somehow say that prejudiced the defense.
Counsel, you've confused me. Mom didn't testify.
Oh, mom didn't testify, but the victim testifies. Thank you for, I apologize for, if you will, muddling the record. Victim testifies, I told Anderson, which I'd actually like to come back to. Then I told my grandma. And then at a later point, I told mom. And she just says, and I told grandma what happened is the testimony. And then I later told mom. Again, not even saying what happened. So I just want to talk about mom's testimony because I think that's easiest to dispose of. Because the victim testifies, I told my mom and she didn't believe me, and talks about how she never disclosed to mom because mom never believed me. And that exactly folds into the defense theory and helps his credibility determination to the jury, right? The mom doesn't even believe her, never would believe her. So I suggest that the defendant can't prove that prejudiced him because it helped him. And
you might be right ultimately in all that, but what concerns me here is, one thing I liked about Commonwealth versus King is that it kind of cleaned up all of these issues, or at least I thought it was going to clean up a lot of these issues with multiple complaints coming in. So King says we're going to have one complaint, the first complaint comes in.
Right.
But then in this case, there is testimony that you can infer other complaints were made, although the content of those complaints may not have been in. But isn't that kind of contrary to the spirit of King? In other words, ultimately you may be correct, there's no prejudice, but shouldn't, in the prosecution's presentation of the case, shouldn't the first complaint evidence be presented? And then, if the defendant is going to go down the road you're talking about well, you're telling the whole world because it's one big lie, isn't it up to the defense to draw that out?
Sorry, I mean to
Sure.
interrupt it. So I think you pose an interesting question because I was thinking about King as I obviously wrote and thought and briefed this case. And King was in 2005, right? And if we think about, that's when King was issued. And if we think about the kind of cases that was modifying fresh complaint, this multitude of, lots of people coming in and saying, I told everybody, and then those people coming in and telling, I told people. So a lot of the cases my sister relies on are within that gamut. Like, actually, she relies heavily on Haggett, on Velasquez, where there's people coming in. So if we can just, I'm gonna present hypothetical in my own argument. But let's say mom did come in to testify in this case, and then mom says, well, then I told a therapist, and then I told the police, and then that's the kind of rubric, if you will, that King tightened up with fresh complaints. And if I could just go on to talk about how, I think it's Alvarez that then modifies in 2011, modifies King. And I find this very interesting as it applies to this case because when King comes out, it's willy-nilly. There's so many errors that happen after King that are in published cases that are kind of modifying and curating it. And Alvarez says, actually, it's not really an evidentiary rule, because the cases we're looking at is evidentiary rule that changed the standard of review. And Elvis says, actually, we really need to look this as a principle, because as we're talking about it right now, it's so fact-specific. And what we see in the genesis of the law as it evolves up until the current, and I suggest to you things like McCoy, I'm going to talk about Medeiros, this idea that it was almost too stringent in that it would not allow defense to harness helpful evidence in cases like this. Because if we're talking about sexual assault cases, there's only so many defenses. It wasn't me, it didn't happen, or they were lying. And so if the courts were to apply King so stringently, it would really foreclose this whole defense theory if it wasn't kind of allowed for this kind of defense. And here, right, as the Commonwealth is preparing, right, because I see you saying, is it appropriate to be offensive or defensive, right? And as the Commonwealth is preparing, you're anticipating what the defenses could be. And I think as the evidence is here, as I just mentioned, there's only a few defenses to a sexual assault case. It was evident that this one was going to be that she was motivated to lie to preclude custody or visitation. I know that was a very long-winded analysis.
Well, let me simplify it then. What if the defense objected to this evidence?
I think that's a great question. If they objected, then there would be limiting instructions, there would be sidebars, and evidence would be curtailed. And I think that it didn't happen here, because if you look at the case, the defense attorney uses it as an opening, he uses it in cross-examination, and he uses it in closing. He cross-examines, we talk about the grandmother, because again, I really don't think the mother really gets us anywhere. But if we talk about the grandmother, we really have to look at the evidence, because the victim testifies to what she repeats what she says she testifies, that she told Anderson all the allegations. But Anderson testifies that the victim only reported a groping of the breast. So meaning that the testimony from the first complaint is only one instance, right? And that the defense theory is that she later embellishes, if you will. It's not just I don't want to go, I want to stay with Anderson. It's not I don't want to go home, but I want to put the nail in the coffin and send him to prison so I never have to go there again. And I think what evolves is that the grandmother's testimony, just I told grandma what happened, folds into this idea that she's not fabricating to the jury today, she indeed told her grandmother. But I think it's also important to see how it's utilized by the defendant, because he utilizes this grandmother idea of someone that was close to her and she never tells. There's one incident, doesn't tell. 2, 3, never tells. And then, oh, eureka, she's going to tell her at the moment she tells Anderson, when she can capitalize on that. And she is portrayed as this manipulative liar throughout. That's the whole crux of the case, that she kind of, if you will, sat on it, elaborated, and then the big punch was at trial. So again, it's all goes to the tactical, and I think it just fails to show a substantial risk that the jury would have found a different way if any of this had been actually objected to, and it wasn't.
One thing that wasn't tactical was not asking for the limiting instructions when the victim talks about the first complaint. And we do seem to have said, working just off the guide to evidence, that you have to give the instruction even when it's the victim's testimony. So what can you tell me about that?
Sure. So the 2 cases my sister cites are Cruz and I think Hadgett. In both of those cases, there was no first complaint witness. So the error in those cases was that the victim said, I told my first complaint. So essentially, the victim was allowed to testify twice to her allegation, and that was where it was erroneous not to give a first complaint instruction. But
I get that, but we did write, and not too long ago, that you have to give it when it first comes in, whether through the complaint or the first complaint witness, repeating word for word what the guide to evidence says.
So I don't think there's a harm where it was given. And again, we have to look at it in a global way, right? Because the defense attorney wants all these iterations to come in. Because as I just explained, the victim's testimony is different than the first complaint's testimony. So to capitalize on this as consistency, I think that very might be so, that the first complaint instruction should be given, I guess, 3 times, because now it's with the first complaint and then in final. So I guess we're saying, what, the first complaint instruction needs to be given thrice in each trial? That sort of seems like overkill. But if, I guess the question is it a timing thing? I don't know. I feel like then we're putting the cart before the horse if you're I don't, it's a very good question, but I don't think this is the case. I don't think this is the case where it needs to be resolved, and I don't think this record really would support those nuances that would need to be grappled with to decide whether or not that would create a substantial risk or prejudicial error. If I could also turn to the question about the jury question, and I feel like I briefed this sufficiently, but I think my sister misunderstands the question. I think the court posed those kind of questions to her. But it really, the question really gets to, are these witnesses credible? Because there's no corroborating evidence about DCF. There was nothing to say, there was no DCF person to come in and say, actually, the defendant did petition for custody. Because the testimony is only that Anderson says there's a possibility of visitation with the defendant, right? So I think that to somehow, however the judge would have answered this question, I think would have either been interpreted as shoring up the credibility of the 2 witnesses, because if it's sure he's petitioned, right, then we're...
What about just disregard it? That's not your consideration.
I mean, I guess he could have said that, but I think...
Isn't it much like when people ask about sentencing? Could he get the death penalty?
Yeah.
Right? You come back and you say, that's not your concern.
I know, but I understand your point, and I absolutely agree, but I think this question talks about the victims. It says, is there a possibility, and I have to say, I want to be like a lawyer and say anything is possible, but that would also have been an inappropriate answer. Is there a possibility that the victim will be back in the defendant's care? Is the victim aware of that? And I think the trouble with answering it in that way is that when they ask, is the victim aware of that, it ties it back to her credibility and her state of mind and what she's thinking. And I feel like it would be a rock and a hard place for the judge to answer it in any which way, because I think it would implicate the credibility determination in answering that. All right, I see there's no additional questions. Thank you.
All right, thank you both. This is a difficult case, and it was well argued and briefed, and we're grateful. We're going to take our mid-morning break. We'll be back in no more than 15 minutes.
Court, all rise. Or stand in recess.
Welcome. I know we have some new people for the next 3 cases, and I'm not sure everyone was here at the beginning, so I'll just introduce ourselves again. I'm Justice Joseph Ditkoff. To my right is Justice Sabita Singh. To my left is Justice Christopher Hodgens. In the Massachusetts Appeals Court, each side gets 15 minutes. There's no rebuttal. We have a clock there. It'll start counting down from 15 when you start. When you get to 90 seconds left, it'll turn yellow. And then when you run out of time, it'll turn red and start counting up. And when it turns red, you can finish your sentence, but please don't say anything else unless you're answering a question from a judge, in which case, please complete your answer. We have read the briefs. We've looked through the record, so you can assume that we are familiar with the case and you can get right into your argument. All that having been said, I'll call our 4th case, number 23P 1067, Norman versus HARYSLAK. Wonderful. You're up first whenever you're ready.
Good morning, Your Honors. My name is BRENDA HARYSLAK. I'm pro se appellant. And I'm here today to ask this honorable court to reverse the decision of the lower court that's before you today, because the lower court erred in granting summary judgment to the appellees. My focus of my argument is on really 2 things today, and I'm sorry, I'm nervous. I've never done this before, and I'm not a lawyer. But I did want to start with case law, Gannon versus Ainsworth, 283 Mass 488, 1933, and that is for a plaintiff to recover for a breach of contract. He or she must show his or her own full and complete performance of the obligations of that contract. Also, Mass Superior Court Civil Jury Instruction encompasses that same thought too, to my understanding. The lower court erred in their decision by granting the appellee summary judgment without facts or proof. At no time during discovery did the appellees produce a single document or any witnesses to show that they did the due diligence in obtaining a mortgage for the 94 Main Street property. There isn't anything in the record. There's a lot of stuff in the record of them trying to obtain the mortgage for Bear Hill Road, though, and there's an abundance of that information back and forth in the emails. Pretty much what a normal conversation looks like when 2 people are trying to buy a house and they're speaking with their agent and their real estate agent and their real estate attorney. They were obligated legally to act reasonably promptly in providing additional information that was requested by the mortgage lender for Main Street on December 7th. There's no evidence in the record showing the appellees did this for the Groveland property. But as I said, there was substantial emails revealed during discovery of significant efforts for the appellee's application for the Merrimack property, which they ended up buying. These emails are the emails that the appellee's attorney tried to pass off as efforts made for Groveland Main Street property on page 12 of his brief, which was very misleading. Fair dealings are expected in real estate contracts, so when the appellees put an offer on the Merrimack property on December 17th and they wanted out of the contract, that would have been a good time for them to have notified me. I did not find out about this property until my real estate lawyer told me January 3rd, which was after I put a substantial deposit on my house in Methuen. The appellees orchestrated not getting their mortgage commitment. It shows in the record several times of them wanting out of Main Street. I can direct you where you could see it. Sorry. Just 1 second. So it would be found in the record appendix, page 273. 273, all of them would be around page 273 of the record appendix, where the appellees, the woman of the appellees, the wife, is saying that It looks like she put an offer on a house yesterday, which was the 29th. But the one I'm looking for, let's see. It looks like we'll be able to get out of Main Street. And that was said on December 28th.
I mean, I read all those text messages, and it seemed like they really wanted your property, but they were quite convinced that you were going to cancel because you'd never find suitable housing otherwise. And only at that point did they start looking for a backup house, knowing that they were risking $1,000, but hoping they could use the mortgage contingency to get out of the Bear Hill.
Right. Well, it wasn't that I wasn't looking for a house, and she also says in those emails, too, that she had knowledge that I had put 8 offers on 9 different houses during that stretch of time. I was actively looking for a house. I got a release of funds on December 28th. I got a release of funds email from them, and their reason was because I did not find suitable housing. So the next day I went out and I looked at a house that I had been looking at, but I knew nothing about the city of Methuen. So I actually went and looked at it because the house was right up my alley, perfect house for me and my family, but I didn't know anything about the city. And so on the 29th I went and I ended up putting an offer on that house, and I did have my house in Methuen under agreement before the clock ran out on that contract.
Well, that's not what you testified to in your deposition. You said that on December 30th there was an offer given. We had to wait on the husband to confirm for it to be like legit because he was away. And then you testified the husband confirmed the next day.
Which was the 30th.
December 31st.
No,
what you testified
no,
to
I
in
saw
your
the
deposition.
property on the 29th, which actually is confirmed in the emails with Kit Normand, the appellee. That she saw that I posted it on Facebook, that I was under verbal agreement on the 29th, and it was official on the 30th. And a lot of dates were written wrong in the deposition. The deposition was never fully put into the appendix either. So corrections that I made might not have made it back in there, to your eyes, because the whole thing was never submitted.
Never submitted to who?
To the lower court. The whole package was never submitted to the lower court. Only bits and pieces of my deposition, but I had gone in and sat and gone through everything and made corrections, and it was, a year and a half ago. So I don't. But just to confirm that even Kit Normand is saying in these emails she saw on my Facebook page, we were not Facebook friends. I did not know she was looking at my Facebook things, but she even says right around that same record appendix pages that I just gave you, 273, that she looks like she put an offer in yesterday, and she said that on the 30th. Yesterday would have been the 29th. That was when the offer was made. We did have to wait for the husband. The house was under agreement on the 30th. And that's why I was, if they had told me we found a house we like better on the 17th, we may not be here today, because I was struggling to find a property. But that was not the case. I didn't even find out from them ever. I found out from my real estate agent on January 3rd. The appellees they tried to make it look like in their writings that this contract ended on December 30th. It did not. The contract ended on February 2nd. That was the date of the contract ending. So there was a lot of wiggle room here for this to have been corrected, but the truth of the matter is they found a house they liked better, and they wanted out. And this was really unfair dealings, especially in a horrible market. They also want to say they were buying and selling and acting like I was just selling. I wasn't just selling. I was hoping to buy also. So the same pressures were on everybody. And yet the judge gave them weight with, they wanted to get out of it. That's not fair to all parties involved in the contract if you're going to side with one party and say it's okay to.
We're going to have to figure out this deposition thing, because in the supplemental appendix, I'm looking at a deposition where you specifically say that you didn't have the agreement until December 31st. Now,
I've never said.
if that's not what was given to Judge Tabbitt, then that doesn't really matter. But it's hard for us to review Judge Tabbitt's opinion unless we know what Judge Tabbitt was looking at.
Well, I understand that, but I have concrete proof from the appellee saying she saw my Facebook post that I said on the 29th that I was under agreement with that house. And that was the only time I was in Methuen, I think, until I moved there. So, I mean, I was there on the 29th, and then it went into agreement. So if I have concrete proof here, I mean, I feel like I felt like the decision sort of looked like he didn't really read my side. I felt like the decision was very one-sided. I've never heard somebody say somebody can get out of a contract just because they found a house they like better or just because they want to. They needed to fulfill their obligations of the contract. And if there was a question about that, why not? I mean, their behavior obviously showed that they did not want to work this out with me. And I was already on the hook for a house now because the day before, which again is in these emails, the day before, they said, the reason we want you to sign the release for the funds is because you don't have suitable housing. It was not because they didn't get their mortgage commitment. It wasn't. They never said that. So that was the fair dealings. Yeah, on December 29th, the appellees and the real estate agent tried to get me to sign a release of the earnest deposit. And they stated, quote, "The buyers want to void the contract because the seller has not found suitable housing. The seller does have till December 30th to find housing. We understand that. I just wanted to get this document out and get the seller prepared," end quote. At no time did they state on December 29th that they want to be released for a lack of mortgage commitment. I feel like the lower court erred when they emphasized that the appellees had a pre-approval from the lender. The appellees did not just have a pre-approval, they had an underwriter pre-approval with a punch list of items that they needed to provide their lender. There is no documentation or witnesses in the record that they fulfilled this obligation. So first, the appellees are stating that they want out of the contract because I didn't have suitable housing. But once I fulfilled that obligation, now on when I filled the obligation on December 30th, now they're saying it's because they didn't get a mortgage. I was now under obligation for the Methuen property when the appellees began to look like they were going to breach the contract. I couldn't put my Groveland property, Main Street, back on the market because I was told by my real estate attorney I would be in breach. So for the whole month of January, I had to just sit there and take it. I couldn't do anything with what they were putting me through. I had to just sit there. I couldn't remarket the house, but I was on the hook for Ditson and Methuen. Yeah, so I was told I would be in breach if I didn't follow through with the entire contract. And it got to a point where I actually felt foolish, but I was following the advice of my real estate attorney. So,
The real estate attorney told you couldn't return the deposit and be done with it?
no, because I was on the hook for my house in Methuen. I would have lost a lot of money. And I had no way of, the house I was selling on Main Street in Groveland was, it did eventually sell, but it was unusual. It was very, very large. It wasn't your typical home that people will buy. It's huge. And I was downsizing. So I wasn't comfortable, like, why would I even let my buyers off the hook? Like, am I allowed to ask you that? I don't know. Like, why would I let my buyers off the hook? They're under contract to buy my property. I'm under contract to sell it to them. I did everything I could to sell them my property.
You said your attorney told you that you couldn't move on, but I'm trying to understand whether your attorney told you...
He said I couldn't move on until February 2nd.
You couldn't move on at all? You couldn't move on without returning the deposit?
I couldn't move on. I'm sorry, did you ask me something?
Yeah, did he say you can't move on, period, or you can't move on unless you return the deposit?
He didn't say either of those things. He just said I had to fulfill the entirety of the contract, which ended on February 2nd, meaning I had to move my stuff out. So I had 3 huge pods containers in my driveway and on my grass, filled with 98% of my stuff, and I had to show up with a deed at the lawyer's office, which when they didn't come for the walkthrough the night before, I felt very stupid doing that the next day. But it was under the advice of my lawyer, so, I didn't want to be in breach of this contract at all, so I did everything by the book, and so that was, and the funds that I typically would have allotted for my mortgage at Main Street had been used for the down payment on my new property in Methuen. So as my buyers eventually ended up breaching our contract, I now had to make 2 months of mortgage payments that I wasn't expecting to need to, as well as insurance payments on a house that I had thought I had sold. Furthermore, as the appellees continued to refuse to buy my property on Main Street, I had to keep from losing my deposit on my new property in Methuen. I needed to increase my original offer by $10,000 to keep them interested in me as a buyer and not lose my deposit. The offer helped, but the sellers were able to continue to market my new home and entertain offers, which led to substantial stress on me and my teenagers. This was an unbelievable, stressful time. I don't know if I can convey it to you, to have to wait like 23 days, knowing the house that you are fighting for now that turned into this whole thing. Other people are able to look at it, and if they put an offer in that the seller wants, they can just sell it. So now if this happened, I'm back to square one.
Your time's up, so we'll have to,
okay,
we'll have to
sorry.
leave it there. No, it's fine.
I thought I was going to be standing here with nothing to say. Thank you so much. Did you have any questions for me? No? All right, hope I got everything in.
We try to ask the questions while it's going on, rather than wait. We try to ask the questions while it's going on.
All right, thank you so
rather
much
than
for
wait
your
to the
time
end.
today. Appreciate it.
We'll hear from counsel for the buyers now.
Good morning, Your Honors. May it please the Court, my name is Christopher Hemsey, and I represent the appellees, the Normans, in this matter. I was also the attorney who represented them at the trial court through the summary judgment. So I just want to address, I know that both briefs were very comprehensive, as was Judge Abbott's written order on summary judgment. And I just want to make clear that I was not trying at any point to belittle the appellant's stressful time, because both parties were buying and selling. Both parties had families that they were trying to protect. And both parties were living in what has been testified to as this really unusual seller's market, which put various, I think practically put various factual pressures on the parties as they were trying to navigate the market while trying to protect their family's interest. And at the most, I would say that both parties had the same amount of stress in this time. They both had real estate attorneys and both had real estate agents, and I think that that's important as we go through some of the emails. We had conducted discovery according to the tracking order. I had noticed a deposition of the defendant, and we had presented an appendix according to the rules of the Superior Court.
So let's talk about that. Was the entire defendant's deposition in that appendix that was given to the...
No, the only things that were in the deposition for Judge Abbott were those that were cited in the statement, the material statement of facts that both parties participated in. So when I think Ms. HARYSLAK was the first party to, I think I responded with a cross motion for summary judgment, and so I had responded to her statement of facts with the entry of the appendix.
This is a problem because you've put the entire deposition in your supplemental appendix, and we need to have what was submitted to the Superior Court.
Well, that was kind of my point in terms of the incorrect appendix here from the appellant, was because I did provide all that was relied upon by Judge Tappett from the Superior Court. But as a matter of practice, and I've never added to an appendix in a summary judgment motion something that was not relied upon or cited in my brief. what typically occurred was if there was any additional testimony that was required, that would be added as well.
No, no. The only thing that can be in an appendix is stuff that was submitted to the Superior Court.
Oh, I'm sorry. I was speaking in terms of the summary judgment record.
No, you gave us this appendix here that we allowed, as you had of right, because it was an informal brief. But the only things that should be in it were things that were given to the Superior Court. And now you're telling me that this deposition here, there's more of it in there than was given to Judge Tabbitt. We can only consider what Judge Tabbitt saw.
I agree entirely. I only cited to that which was in the statement of facts from the summary judgment. So I'm not using any part of that deposition that was not relied upon.
What I'm saying is you're going to have to redo this supplemental appendix and give us only stuff that was given to the Superior Court judge.
That's not a problem.
The defendant's deposition is extremely important in this case, but we need to know exactly what parts of it were given to the judge.
Absolutely, I can do that. That's no problem. I over-included. I wasn't doing anything.
I understand why you did, but you need to undo that. You're going to need to give us a new supplemental appendix that's just the stuff you put in here, but only the stuff that's in here that was given to the Superior Court judge.
That's not a problem, Your Honor. Absolutely. But I think that the two issues, one being more of a common mortgage contingency issue, and the other one is a little less common in terms of the suitable housing, but the mortgage commitment issue, I think there are some issues of fact that what Judge Tabbitt was commenting on in his holding was that there was a lack of facts in the record that would suggest that any of the theories that were presented by the defendant were anything more than speculation. In other words, if there was a witness that should have been deposed or some fact that should have been provided at summary judgment, that it was the defendant's requirement in order to present that contested facts such that would preclude the entry of summary judgment. And I think Judge...
Well, let me ask you about that. So Jason Norman's affidavit says, one of the factors that was not yet complete by the December 30 mortgage commitment date was getting the bank the requisite documents they required. So why doesn't that show, since the contract required you to act reasonably promptly in providing any additional information required by the mortgage lender, why doesn't that eliminate compliance with the mortgage contingency?
Well, I believe that would be an argument that a defendant can bring, but that was regarding the loan that they had received from a family member in terms of a deposit. And that was an issue during the underwriting process that they were questioning it. It wasn't necessarily that it wasn't provided, that was just offered for a context of that the argument that they sat and didn't provide what was requested of them reasonably by the bank was not done by them. It wasn't this conscious ignorance of their requirement in terms of to get out of this contract in order to go through with another contract.
Right, but the contract says, in no event shall the buyer be deemed to have used reasonable efforts to obtain financing unless the buyer submitted at least one application to a licensed mortgage lender on or before, applied, and acted promptly, reasonably promptly, in providing any additional information requested by the mortgage lender. So where your client wrote in his affidavit that he didn't get them the documents they needed, why doesn't that create a genuine issue material fact whether this contingency can be invoked?
Because I don't believe, Your Honor, that there is any evidence in the record that would suggest that they didn't respond reasonably to any request provided of them, which is certainly a fair question in terms of the discovery process, but that affidavit is not, in order to offer that explanation, it wasn't to suggest that they didn't provide it, because even after January 2nd and into January of that following year, the emails show that even on financial questions of income and other typical underwriting questions, they were still back and forth. In other words, that they were promptly responding to those questions that were offered to them by the underwriter. I think what was practically going on at the time was that there was a lack of action through the bank through the holidays, and whatever was occurring, all of the agents were trying to prepare for the New Year's, which is what that email was cited by the appellant, which was in that December 29th when her agent, the defendant's agent, had even about noontime on the 29th, that she was still actively looking for suitable housing. I think that the those two contingencies, either one of which can be not satisfied, and either one of them could be used to return the deposit to the buyers and to void this contract. And there was no evidence, as pointed out by Judge Tabbitt, that there was any failure to reasonably act on the parts of the buyer or the Normans in order to buy this subject house. And regarding the arguments that were presented in the brief by the appellant, there is no requirement that you have to submit a denial letter, because it's not a question of whether or not it was approved or denied, because there's always an issue of an extension of time, which led to another argument that suggested that you needed to ask for more time if you didn't have a firm written commitment by the mortgage commitment date, which is also not a requirement. I believe Judge Tabbitt noted in his opinion that would be adding language to an otherwise clear and unambiguous provision of the PNS. So the requirement to ask or to, in this case, I think it was about 4 o'clock on the date of the deadline, the 30th, where the seller's attorney had said, well, did you get the mortgage? No. And then the response was, well, we'll agree to extend it. So I think in this seller's market, in this highly stressful time for all parties, I believe that the seller's attorney Cohen, had tried to do some things to save a deal in an otherwise difficult market. What the difference of what the attorney tried to do and then what the buyer's attorney responded with was just noting that because you're going to offer to give me an extension to the mortgage commitment date doesn't require me to accept that offer. Typically, buyers, if they want to go forward, and there was a lot of factors here that would suggest that this particular seller in this particular deal, there was other issues, even if they got past December 30th, that would make that February 2nd closing date not something that these buyers could rely upon in order to protect the future of their family. And I think that those emails between the 29th and the 30th, particularly when words matter, and I do believe words matter in that suitable housing provision, where this litigation in part, as it relates to that suitable housing provision, and as cited to Judge Tabbitt, and also, and I will supplement the supplemental brief, Your Honor, but some of the facts that were important, I think they are important, is that in the deposition, that Ms. HARYSLAK did not believe that the provision was worded the way that it was, in that said that if she didn't find suitable housing, that either buyer or seller could void the contract. She believed it was only held by her, and I understand that. It's a contract, and there's a lot of provisions of a PNS and a rider.
No, I'm not sure why it matters what she thought. I mean, you asked her a lot of questions about what she thought about the contract. I mean, the contract, we determined its meaning de novo, right?
Yeah, absolutely. And I do understand that. It was only about the intent of the parties, because eventually that Ms. HARYSLAK did admit that in reading the PNS in the way that it actually read, that it was intended by all parties, or both parties rather, that buyer or seller would be able to void the contract if seller didn't find suitable housing. And so when we look into those facts leading into the deadline of December 30th, it's very important because, and even in Attorney Cohen's affidavit, that the arguments of satisfying the provision versus waiving the provision, I think, is very important. And there was no knowledge of this offer to purchase on the new house that satisfied the suitable housing until 3 days later on January 2nd, approximately 4 p.m., which incidentally also corresponded to when MLS had that listing go off there as under agreement. So that's very important because in real time, the attorneys that were dealing with one another, as well as the agents, the real estate agents that were dealing with one another, not only was there a continual representation from the 29th onward that they were trying to look for houses. Not only was that also stated in the social media posts of a knowledge that the sellers were able to walk and did that, if Ms. HARYSLAK didn't find a suitable housing replacement. But also, when that issue was directly spoken about by the attorneys, it was the seller's attorney who stated that, well, no, we're waiving that, so we're going to be ready, willing, and able to do that. And similar, there's even though like a mortgage commitment generally protects the buyer, it's been noted that there's an incidental benefit to the seller in that knowing your future, whether or not you're able to rely on the closing happen. And I think in this situation, the reason why the buyers put it in their offer to purchase, and it was also put in the PNS about them being able to waive, is because in light of the market and the stress of everybody that everybody was sharing, that they were entitled to act in the failure of that condition or the lack of satisfaction of the condition in a situation that they felt best.
Well, this is just a standard form, though. I mean, this wasn't drafted just for this particular transaction, so the market conditions at the time really didn't play much of a role in the language of the contract, did it?
Yeah, I think it's a little unusual of a wording, but it was. I only offer that it was in the offer to purchase because it was the buyers who actually carved out their ability to void the contract should seller not. And I found that to be a little peculiar, but it was in the offer to purchase that was then mirrored in the PNS. So it's a little different because the argument that I think that was advanced in the appellant brief was that, well, this is a provision that benefits the seller, and so therefore somehow limited the buyer's protection of it, which I think at the time that these parties knew their fates and knew what was going to happen as of that deadline of December 30th, that they could then move on with what they needed to do to protect their own rights and concerns.
I mean, do we think it's standard language? It's put in the additional provisions of the purchase and sale, the housing contingency. Is
the housing contingency
drafted for its own purpose, or is that standard?
I think the housing contingency does have more. I think it's more common than but it's not. That's certainly not in everything. It is an additional provision, which, just by nature, doesn't make it into that form PNS. But in this case, I think that it was there, clear, unambiguous, and entitled for protection for both seller and buyer.
All right. Well, time is up, so we'll have to leave it there. Thank you both. We'll take this under advisement, and we'll send a written decision. You're going to have to fix that appendix. We'll get you an order about that, too.
Okay.
Average time is about 2 months to get a decision, but it could be more or less depending on our workload and our discussions. So that's
Thank you very much.
We'll leave it. All right, I'll call the next case, LASCOM versus LASCOM, number 23P678. Whenever you're ready, Counselor.
Thank you. Good morning, Your Honors. May it please the Court. Brian Waller on behalf of the appellant, Matthew Lascom. This case demonstrates why a recipient spouse's need for alimony should be the starting point for determining an alimony award. The alimony that was awarded here far exceeds the wife's need, the recipient spouse, and exceeds the husband's ability to pay. As a result, or up through the time of this modification judgment, the husband's income increased 9%. The change as a result of this modification judgment was that his support obligation increased 66%, or 82% when you factor in the $250 of arrears. And that has led to a ripple effect of many other things, including a big arrearage balance that continued to grow because the Department of Revenue couldn't withhold the amount because there's a cap on the amount of disposable income that they can withhold. And this exceeded that. And here, the lower court ignored the party separation agreement.
Well, there's specific reference to the separation agreement, right?
There is, but there's not reference with regard to the parties. I guess it acknowledges that the wife had a deficit at the time of the divorce of $237 or something along those lines when she signed the agreement that had total support of $900. And then it didn't, the amended judgment of modification didn't factor in that the wife didn't, as a result of that separation agreement, receive the maximum potential alimony that could have been awarded. And I think the court's application of the 35% alimony award here was in error. The statute reads that an alimony award should be based on the recipient spouse's need, or 30 to 35%, or not to exceed 30 to 35%.
You keep saying need, but I don't know how we would know that this is more than is necessary to keep her in the style of the marital household before the divorce.
So I believe that's evident from her financial statement. If I did a comparison of the two, and the court references, or the lower court references their prior financial statements throughout the modification judgment, her expenses did not increase significantly, and from the time that she accepted the $900 of total support at the time of divorce.
But you're talking as if it's axiomatic that she was able to maintain the lifestyle she had when she was married with the expenses she had. And I don't know why we have to accept that. And the judge found that both parties were at a deficit under the original agreement, so presumably both of their lifestyles were in the beginning actually decreasing.
I believe the court found that the husband had a surplus.
Well, she had
at the time of divorce. And as a result of the modification judgment, he had a significant deficit and the wife had a surplus. It doesn't make logical sense that his income could increase 9% from the time of divorce and have that translate into a 66% increase in his ability to pay alimony. And that's where I believe the lower court should have taken into consideration the separation agreement and the relativity of their agreed upon support number at that time.
It sounds like the judge was maybe saying that there just wasn't sufficient evidence presented by the parties regarding the separation agreement and why it was structured the way it was.
Agreed. And the judge made that finding, or I know she referenced that, and there certainly wasn't testimony as to the the background of how they reached that settlement.
So difficult to say that that's a judicial error.
I'm sorry?
So it's difficult to say that that's a judicial error, not taking that into consideration when it...
I think she could consider the separation agreement based on an evaluation of their financial statements and their financial status at the time of the divorce and at the time of the modification. That didn't require any further testimony. And she made findings to that effect, that the alimony, or that the wife still had a deficit, taking into consideration the $900 support award at the time of divorce.
I can understand why the husband would be upset as to what happened here, where there's an agreement adopted by the judge, a couple of years goes by, and 2 of the children are emancipated, so in his mind, he's thinking, well, there's a change in circumstances, my alimony obligation should go down, let's go in and talk to the judge about it. But the risk in doing that, and correct me if I'm wrong, but the risk in bringing the complaint for modification is the judge has the discretion to go back and look at the entire picture, and all the gains that the husband may have thought he had up to that point could be lost. Isn't that true?
To an extent. So what happened here was the husband filed the complaint for modification. The child support guidelines changed after he had filed that, which led to a much larger increase in the child support amount. Then, based on discussion with his counsel at the time, he decided to file a amended complaint for modification to include alimony so that the 2 numbers could be adjusted together to reach a final amount of total support for the wife. I agree that did open the door to an upward modification, contrary to what he was seeking. But the level of that modification or the level of that increase seems to be just plainly wrong and excessive. It puts the wife in a completely different financial footing than she was at the time of the divorce, as well as puts the husband in a tremendously difficult financial position.
Counsel, you make a compelling case that the wife's expenses are overstated by $200. But putting aside your argument about her need, it didn't seem like her expenses went into the calculation the judge made of alimony. Am I wrong about that? Looked like it was a comparison of incomes.
Correct. And that's our position that
I know you think that's wrong, but I just want to make sure I understand
Yeah.
the math.
Right. So the judge went right to the 35% of the difference in their incomes as the calculation for alimony, as opposed to reviewing the wife's need first. Sorry. Another issue that we believe was an abuse of discretion was the retroactive application of both the alimony and the child support. With regard to the child support, there were no findings and no testimony or other evidence presented that the children weren't receiving sufficient support during the pendency of this complaint for modification.
Doesn't the fact that the guidelines would have had a higher number presumptively means that the support was too low? Isn't that what the SJC tells us?
There is a presumption. However, there was no evidence supporting that, or I guess contradicting that. But typically there would be a finding that the children were not supported to a level that they should have been. There's no evidence whatsoever, no testimony from either party as to the children not receiving sufficient support, as well as the retroactive adjustment of alimony for the wife. Since the time of divorce, she accrued no further debt. Her assets increased, which should have been expected based on the division of assets. But she was maintaining the marital lifestyle without incurring any debt.
And how do we know that?
Just a comparison of her financial statement from the time of divorce to the time of the modification. All of her assets increased with the exception of her vehicle, which decreased just through depreciation.
How do we know her expenses in the agreement are what the marital lifestyle was?
What was the financial statement that she filed at the time of divorce? And presumptively, at the time she accepted the $900 of total support, knowing at the time that she had a deficit, she was confident that she could continue to maintain the lifestyle she was living at that time.
How do we know that?
I think you have to infer that from her acceptance of the agreement and the amount of support provided, as well as the extrapolation to the present day where she has no additional debt. She's not living on borrowed money. She's able to meet her needs, as evidenced by, no additional liabilities.
So it's not possible that at the time of divorce, she's actually living below, her standard of living is actually below what would be expected?
I believe that's possible, and I would say probably likely for both parties, that their lifestyle decreased or relatively as a result of having two households dependent on one income, or one income and some part-time work. And that actually brings another issue that the wife testified that she didn't need to work more. She had the ability to work additional hours at the job that she had been working, and she chose not to. She also could have worked full-time there or had the availability of retirement benefits had she worked full-time there, and she chose not to. And the judge seems to make much of the fact that the wife is not making retirement contributions and has no ability to make contributions, but that's sort of a result of her own decision to work part-time and not to seek a position where she could earn retirement benefits.
Well, she testified she does that to be available for the children. Is that not a proper consideration for a custodial parent?
I believe it would be when the children were younger. At the time of the modification, there was one under 18, and I believe he was graduating high school at that time. But I think, in general, the court reviewed and essentially reanalyzed many of the factors when determining the alimony. But I think there should be some tension there between what the parties agreed to at the time. Essentially what happened here was the wife had a full relitigation of the agreement that she agreed to at the time of the divorce that benefited her tremendously and penalized the husband tremendously. And it doesn't represent anything like the agreement that they entered into at the time of divorce. And it seems pretty evident that the husband, that final divorce judgment wasn't something that the husband would have agreed to at the time of divorce, because it put him in a position of significant deficit, and the judge basically precluded him from making retirement contributions because the wife wasn't able to, based on her job situation and her choice to work a limited schedule. So I see that my time is almost up. If there's no further questions, I'll rest on my brief.
Thank you, Counselor.
Thank you.
We'll hear from counsel for the wife now. Excuse me.
I was about to say good morning and then realized we're in the afternoon. So, good afternoon. May it please the court. Diana Sladen on behalf of the appellee, Victoria Lascom, who is present in the courtroom today. Your Honor, after listening to my brother speak about his position on this appeal, I would have to respectfully disagree. It's our position that the lower court did not abuse her discretion when she increased the alimony award to my client and the child support award to my client. The central piece here that the court has to consider is the need and ability argument in the context of how a lower court is supposed to order alimony. The lower court is authorized by statute to decide whether or not alimony is appropriate and what level of alimony we should be awarding a recipient. Not one factor matters. All of the factors in Section 53 matter, from the age of the parties to the length of the marriage to their contributions, economic and non-economic contributions towards the marriage. This court and the Supreme Judicial Court has repeated time and time and time again that they will not disturb the findings of the lower court unless there is some type of error or there is some type of misjudgment. Here, the court was well within the bounds of the statute. The statute, as my brother stated, is the recipient's need or 30 to 35% of the difference in the incomes. The court ordered 35%. There was no excessive order here. Now, I take issue with my brother's position on how we calculate someone's need. Admittedly, we have recent case law from the Supreme Judicial Court, Openshaw v. Openshaw, where the court specifically held that, yes, the financial statement is the starting point. That's where we start, but that's not the only factor. We have to look to all the factors in Section 53 when deciding what is appropriate. When we rely just on the financial statement, we rely on an individual's consumption of goods and services. That's what the financial statement reflects when we look at expenses. And the court specifically held that when we only look to the consumption of goods and services, that then there's a presumption that the recipient will then have to either lower their consumption or abandon practices of the marriage altogether, like saving for retirement. So in this particular case, it was very evident that Ms. LASCOM was not saving for retirement from a very basic standpoint and overview of the case. And this court and the Supreme Judicial Court has emphasized, again, the nexus between need and the marital lifestyle. The trial court heard firsthand testimony from the husband and the wife that they lived a comfortable middle-class lifestyle. They owned homes in the multiple locations around the world that they lived. This was a party who each had a vehicle that they were repaired and maintained. The homes were maintained. They were able to save for retirement. They traveled as a family. The children participated in extracurricular activities. The husband testified about owning chickens and dogs. They cared for pets. Post-separation, Mr. was able to maintain that lifestyle. Mrs. was not. Mr. doubled his retirement from the time of the divorce to the time of the modification judgment. His retirement assets, they tripled, not doubled. His contributions doubled and his assets tripled. He had purchased a home with his subsequent wife, which actually had more equity at the time of trial than Mrs. at the time of trial from the former marital home. There were no liabilities on his financial statement other than an artificial loan that he listed to his current wife, which he testified at trial he did not pay. And it's the same loan that's listed on his financial statement at the time of the divorce for the same amount. I think it's incredibly important that this court take deference to the lower court's assessment of the husband's credibility at trial. The lower court did not find the husband credible. His year prior income was off by $40,000. He failed to list retirement contributions from his employer. He had numerous issues with the financial statement, leading the lower court to believe and have difficulty in determining what his actual earning capacity is and what he's earning and how much he has available to order for alimony. So on one side of the aisle, we have a questionable witness with some credibility issues. On the other side, we see a woman who is unable to save. She's unable to contribute to her retirement. Her car, she testified, need new tires and repairs to the vehicle. She's not able to afford to make those. The marital home had a list of repairs that needed to be done. She's unable to make those repairs. The inequity is palpable just from a review of the transcript. And so the court takes all of these things into consideration. We have one party who is doing better and one who unfortunately is not even maintaining the lifestyle that was afforded to her during the course of the marriage.
What do you say about your brother's argument about the judge's failure to take into consideration the agreement of the parties only a few years back, essentially undoing what the parties had consciously put in place?
Certainly, and I think the Supreme Judicial Court in Pierce specifically addresses this issue. A prior agreement is important, and it is something that the court needs to take into consideration, but it's not dispositive. It doesn't mean that we throw out everything else solely to maintain the prior agreement. Now, the difference here, and the lower court specifically addresses the Berkhume issue and how this case differentiates from Berkhume. A prior agreement is important, but in this particular situation, the separation agreement of the parties merged with the judgment of divorce. So issues pertaining to spousal support and child support were modifiable based on a change in circumstances. So the court has the authority to go in and modify the alimony amount, modify the child support amount based on a change in circumstances. Here, there is no express direction, intention, explanation of how the alimony was calculated in the separation agreement. There are no instructions provided to a future trier of fact that in the event that wife wants more down the road, then she will get $300 less than the statutory maximum. There are no instructions here. So the court was well within its authority, especially because the prior agreement, while important and considered, and clearly the trial court considered it because the lower court specifically addressed how it's different from the Berkhume issue, because in Berkhume, there was an alimony provision that merged, but they had waived it. And so the issue wasn't even that there was specific instruction from the parties, it's that the court never considered all the other factors. So in this particular case, the court has to look to, yes, she may have accepted lower alimony at the time of the divorce for a multitude of factors. Maybe she was sick of litigating. Maybe she wanted this to be over. There were still unemancipated children in the home. There's a slew of reasons why she possibly accepted less, but there's nothing in the trial record. Counsel for husband never asked those questions. The evidence isn't there to support husband's position in this matter that they had this agreement and this is what they were going to do moving forward. The court has to use what's before it. And based on the testimony and the matter in which the separation agreement was drafted and accepted by the court was certainly within its authority to do so.
What about the retroactivity question?
Sure. So I would disagree with my brother's representation on the retroactive child support. The Supreme Court in Bolter has specifically held that a judicial determination that a payer has been paying less than guidelines require him to necessarily, the children are receiving insufficient support. And in the lower court, she did make that determination. She stated what husband had been paying throughout the duration of the proceedings, which was 66 weeks. So a year and almost 4 months that this case had been in litigation. For those 66 weeks, he was paying what was prescribed by the agreement of the parties, and she found that the child support should have been higher. And so therefore, there's a finding per Bolter that it's appropriate to retroactively apply it. As we switch over to the alimony portion of the retroactivity, I would argue that it was equitable and the judge made findings to that. She discussed, that the husband had actually saved over that time period because he was underpaying child support and he was underpaying alimony. The lower court also found that his income was likely higher than what the lower court attributed to him. So while the court uses, I believe, a $3,100 a week total for husband, there's a statement by the trial court that says it is difficult to ascertain exactly what he's receiving, but we suspect it's higher. So there are contributions from a current spouse that are not listed on a financial statement. The court infers specifically from his testimony that there was a loan for a vehicle and contributions towards the marital home that he currently resides in, that there are some financial means there, and also the tax implications of the alimony. This is prior to the 2018 tax reform. So for these parties, alimony is taxable to Mrs. and tax deductible to the husband. So based on all of these factors, the court found it to be
Pardon my ignorance, but what happens now? If you got divorced today, how would the alimony be treated tax-wise?
It would, from a tax perspective, it would be treated as if it's child support. So there are no tax benefits, at least with the federal filings, that you are able to deduct it, which is really disadvantageous as a kind of bone as a family law practitioner, because that is sometimes how we are able to have a client not be so upset about having to pay an alimony payment. But that's no longer the case. Now child support and alimony are on equal footing. So the other argument that Attorney Waller makes is the underemployment of my client. And I think it's important that this court take into consideration that, first of all, the trial record is missing evidence to that. There's one question asked in the trial transcript. Could you work more, or have you ever asked your employer to work more hours? No is the answer. Do you have retirement benefits if you work full-time? Maybe. There's no vocational expert discussing her employability, her underemployment, her ability to obtain employment at a higher standard. That is not present in the record. And when we speak to a 55-year-old woman at the time of trial who traveled across the world to follow her husband over the course of 24 years and 5 months, that's what's important. And this court specifically held in Grouper that it's unrealistic and inappropriate to expect in Grouper a 59-year-old woman with limited job experience or training to make up in the marketplace what her husband plainly has the ability to provide. And that's exactly the case here. We have a woman who met her husband in 1992. She was originally the breadwinner. He goes to college, and then she follows him throughout his career. They moved from Scotland to Texas to North Carolina to Massachusetts. In that period of time, the only time she returned to work, truly, was 3 months before the divorce was final. Over a 24-year, 5-month marriage. That's why her underemployment, and I put that in quotes, her underemployment is not something that the court finds credible. The expectation is her contributions as a caregiver to the party's 4 children, a homemaker during that time, while husband was able to advance himself in his career and do better for himself and ultimately the marriage. That's what the court focuses on. And when we circle back to maintaining the marital lifestyle, these people saved for retirement. These people lived the lives that husband continues to live. And my client cannot continue to do so. She's unable to maintain the marital lifestyle under the old alimony order. And that was recognized by the court. And I would even submit to the court that even the current alimony order of $1,000 a week, if we take out child support, because as Kavanaugh stated, child support serves a purpose for the support of children, and alimony serves a purpose for the support of the spouse, she's still at a deficit. If we take child support away, she's still at a deficit. Her weekly expenses at the time of trial were $1,300 a week. And that's taking out the in question $200 a week.
Why would we take child support out? I mean, her expenses include expenses that support the child too, right?
Absolutely, but I think the purposes of child support and alimony are distinct. Child support is for the furtherance of the needs of the children, and while some of those expenses may fall slightly under the same umbrella, she needs, per her financial statement, $1,300 just to meet her basic living expenses. That doesn't include savings, that doesn't include saving for retirement, it doesn't include the dinners out or the vacations. These are all things that are not in consideration.
Fixing the car, fixing the house, those all benefit the child too, right? Groceries.
And I guess the question then becomes, is it more important to have the child enroll in an activity or to repair maybe the rotting wood on a house? I mean, these are all things that the court found within the record. Based on the testimony at the trial, the judge found that she was not able to maintain her standard of living.
All right. Well, thank you both.
Thank you.
We'll take it under advisement. And I'll call our last case of the day. I don't like my chances of pronouncing this correctly, but I'll take a shot at it. HOUVOURAS versus HOUVOURAS, 23P 625.
Good afternoon, Your Honors. May it please the Court. My name is Pamela Pardo, and I represent the husband in this case. The 2021 judgment after remand is clearly erroneous. While this is certainly a high benchmark for reversing the trial court's finding The record in this case exceeds that benchmark. No reasonable person could have reached the conclusion of the remand trial court. In fact, the same judge determined the husband needed round-the-clock care in 2017.
Could you tell me where the judge found that? I did not see that.
Yes, I can. It's at Record Appendix Pleadings 2, page 56. The judge found the care level and medical expenses reasonable given his significant medical needs.
Okay, wait, Appendix 256? That's our opinion.
It's Pleadings 2?
Yeah, Pleadings 256 is the last page of our opinion.
Okay, my apologies then. What I was hoping to cite was the judge's opinion. And I can see if I can find that.
I mean, I didn't see that. I saw him find that he was only getting 10 hours of coverage by an aide at the time, 2017, and that if the daughter wasn't there, he'd need 13 hours per day. I didn't see anywhere where he said that the husband was receiving or needed 24-hour care.
Well, I don't believe that was your question. It was
Okay, this I see it. You're talking appendix pleadings. Appendix parentheses pleadings 56. That is in there. And what paragraph is it? Do you know?
I don't have the paragraph cited. This was a handwritten note, but it's I have it at page 56.
There's multiple paragraphs.
Right,
on
there are
so-
many.
It's somewhere under health of parties.
I'm sorry, Your Honor?
It's somewhere under the health of the parties.
Yes.
I mean, I read this section, and I don't see anything that says that.
So the
Husband does not have Alzheimer's disease, Parkinson's disease, or dementia, or any other mental incapacity. He suffers physical limitations from the result of his strokes. He needs to walk with a walker due to limited mobility. He's not able to bathe or use the restroom without assistance. He relies on a healthcare aide to assist him with most daily activities. Husband suffers from diabetes. There is no evidence to suggest the husband's memory is affected by his strokes. In fact, he testified at trial articulately and intelligently. And that's the end of health of the parties.
Sorry, I was having a little bit of trouble hearing you.
Okay,
I
just don't see anywhere where the judge found he needs 24-hour care.
Well, so the judge found that he was receiving 10 hours of care from the home health aides and an additional 7 hours of care from his children and other people who might assist at that time, although I'm not sure she put it in those words, but it's in the transcript. But in any event, the times that he was not receiving care, he was sleeping effectively. So that's where the round-the-clock care, I think, was instituted. And there's a reference in the judgment of the appeals court which indicates that there was that the husband indicated he needed 24 hours of care because of his health conditions. And I do want to point out as well that the wife stipulated to the health conditions and the husband's condition at the time of the divorce trial. And so the findings of the judge that he needed this substantial amount of care.
Wife stipulated he needed round-the-clock care at the time of the trial?
I think the round-the-clock care is more of a term of art. And I agree that, I scoured this and round-the-clock care wasn't specifically stated. So if I gave that impression, I apologize. The amount of care that was directed by the court was that he was getting the 10 hours of care from the home health aide, and the judge credited that at the time and applied the amount of money that was being paid as an expense, as a legitimate expense and a reasonable expense back in 2017 at the time of the divorce judgment. So,
Okay.
Does that answer your question?
10 hours at trial, yes.
10 hours, but that, I do want to point out there that the children were adding additional time there, and had they not had the family help out, then they would have absolutely needed more time, and that was testified to at trial. And there's a finding by the court I think it's in that same area of the judgment where the judge credits the daughter's testimony that she was in fact taking care of the husband when the carer was not available to do so, and so he was receiving that care throughout the day. So in 2015, the husband suffered 2 strokes and he broke his neck. In 2017, so he was wheelchair bound at the time, and he needed assistance to do just about every activity of daily living. We ask that this court at this point remand the case for further proceedings, specifically to identify what the husband's actual income was at the time, because that was a major reason for the court's finding in 2017, and what his reasonable medical expenses were at the time of the remand trial, which was a directive from this appeals court after the 2017 judgment. And that that once the court has that legitimate information, at that point, they can determine whether the agreement has the same vitality at the time of the divorce that the parties intended at the time of the execution of the postnuptial agreement. Enforcement of the postnuptial agreement at the time would have left the husband without sufficient resources to support himself. That was the husband's position at the divorce trial, and that was his position at the remand trial. The parties' circumstances at the time of the divorce were so dramatically different from what they were at the time, at the time of the signing of the prenuptial agreement, were so different from what they were at the time of the divorce that they have to be considered. They had substantial resources in 2004 to pay their live and live a luxurious lifestyle. But jumping ahead, by 2015, the husband had two strokes, and he broke his neck, leaving him wheelchair bound. Back in 2004, the husband was in good health at that time. So he, in addition to being wheelchair bound, he had left side paraplegia, and he had diabetes, and he was incontinent. And at the time of the trial, the parties were no longer living, it had financial success, but they were in fact in quite a bit of debt at that time. They had both credit card debt and significant tax debt.
But can I just go back to one question? You had referenced on remand that the judge was not considering the proper income and expenses and so forth, but repeatedly in her decision, she keeps making it a point to say, for example, on page 2 of the decision, she says that she's considering the amounts to be fair and reasonable both at the time of the execution and at the time of the judgment on remand. So it sounds like the judge was under the impression that she was considering current data.
Right. So the trial court on remand limited the scope of the remand trial to just husband's current medical expenses. And that's relevant because we argued in preliminary motions that we felt that her directive was too narrow, that it was impossible to determine the actual expenses of the husband at the remand trial based on simply his medical expenses as of that time without considering all his expenses, which changed significantly from the 2017 divorce trial. And akin to that is that at the 2017 divorce trial, he was living with his ex-wife and his 2 adult children in their small 3-bedroom home in New Jersey with their live-in carer. So the daughter shared a room with her dad, the husband. She slept on the couch. What was more important and more relevant for his moving from the former marital home to an apartment was that it was no longer safe for him to remain in the home. He was unable to actually ambulate he could not take a shower. It took several people to get him in and out of the shower. He had to step over a lip to the shower, which was very unsafe. And so for those reasons, he was really compelled to leave that environment to go to an apartment. And this is a man who was left with no economic resources after the trial, so he didn't have the ability to purchase a house. He was really required to rent an apartment at that point. He needed a handicapped accessible apartment. He was clearly at that point, as we've stated, he was wheelchair bound. He had limited use of his arms and legs. He could use his right arm and hand, and that was about the extent of what he could do on his own. Everything else he needed to do with assistance of carers, including sitting up in bed, getting up out of bed, dressing, going to the bathroom, transitioning to the bathroom. He needed help in the bathroom. He needed help showering. He needed help shaving. He needed help getting in and off the toilet. He needed help to prepare his meals. He needed help to eat his meals. He needed help with medication. Medication, I think, is a big issue in this case because he needed medication 4 times a day at specific times. He had hypertension and he had diabetes. So he was unable to get his own medication and needed help with that. And so when the judge limited, as she did in this remand trial, his time with the carers, that she limited that to 4 hours a day, and I suggest to you that was somewhat arbitrary. And in doing so, she really left him with an impossible situation. Home health aides don't just pop in and out, as I think the judge suggests in her decision. Home health aides are retained for a period of time, usually a minimum period of time, of several hours, 3 or 4 hours. And so it's very impractical to implement what the judge found.
Okay, so you're not saying that she was relying on the wrong data, it's just that she wasn't crediting all the expenses that were being claimed.
Yes, but I think that we are actually claiming that she also is relying on some irrelevant and improper information in making the decisions as well. And that goes into the expert testimony of the only witness that the wife presented at trial, which was Dr. Warner, who was a medical doctor. He's a neurologist, and he's clearly a trained and experienced neurologist, but what he isn't is a medical health insurance expert. And he's not a vocational
He's a healthcare fraud investigator.
Well, but if you can appreciate what a fraud investigator does, it's not investigate what insurance claims are. It's investigating whether or not doctors are committing healthcare fraud.
By making claims to Medicare or to other insurance providers.
It's looking at what the doctors are doing and not what is being submitted for actual claims. He's not looking to see whether or not the claims in those situations are the type of claims that are submitted from a doctor with a Medicaid situation where, so if you look at what a Medicaid fraud does and an explanation of that, it doesn't actually include that definition as what medical fraud investigators do, that they are not looking at the specific claim that's being submitted in a case. And to take
where will I find that? I read the voir dire, I didn't see that.
So that's, I believe it was submitted, it wasn't as part of the case in chief in the lower court, but what was, so it was an attachment, I believe, which was not necessarily a proper a document that was appended to the reply brief. So I don't believe it's necessarily something that can be identified. But in any event, the testimony that Dr. Warner provided was beyond the scope of what the trial court mandate was, which was to, he wasn't really there to testify based on the mandate that the husband's medical condition was what it was, and a significant part of his testimony was about the husband's medical condition, which was beyond the scope. But he ultimately made findings about what things cost, like the cost of incontinence supplies and how much a visiting nurse costs. And I suggest to you that that goes beyond the scope of certainly what his qualifications are. He's a neurologist. He's not a vocational
we'll have to leave
expert.
it. We'll have to leave it there unless there's further questions. All right. Thank you, counsel.
Very much.
Hear from counsel for the wife now. Whenever you're ready.
Thank you. May it please the court, my name is Jinho King, and I represent Ms. Phyllis HOUVOURAS, now known as Ms. Phyllis Vellis. We ask that the court affirm the judgment of the trial court. This appeal revolves essentially around the estate's dissatisfaction with how the court weighed the evidence. Weighing the evidence is what the trial court should be doing, and not what this court needs to be reviewing. But to the extent that the estate does argue legal error, it has either failed to preserve it or waived it, or their argument lacks merit. So I will address each of the husband's arguments in the order that they appear in their brief. Obviously, I'm happy to answer any questions.
Sure. Let me just ask you this about the weight of the evidence, because I think it raises an interesting question. So there were a lot of videos that were submitted in the record here. And if we look at these videos here, and it shows that this gentleman is pretty helpless, getting out of bed and so forth. What do we make of that in light of the judge's findings in the case? In other words, if we look at it and come to the conclusion, well, gee, that looks like he needs 24/7 care, but the judge didn't think so, what do we do with that?
Because these are factual findings, as long as there's evidence to support the trial court's findings, this court should defer to the trial court's findings. And so Your Honor raises a great point concerning videos. Videos don't come in a vacuum, right? They come in with testimony that supports it, right? Testimony that authenticates it, that describes it as whether it is supporting one position or another, right? A trial judge and any fact finder has the ability to credit or discredit whatever testimony that they hear. And so it is possible for a fact finder to discredit not the video itself, but what that video represents. For example, if that is a fair and accurate representation of truly their state and what that means, right? A fact finder has the ability to make that determination. And so for this case and these findings, what that means is that this court can accept what the trial court found regarding essentially the necessity of and the reasonableness of the expenses as they relate to the husband's condition. So I hope that answers your question, but that is essentially what the trial court's role is. It is to be the fact finder, and this court can accept it absent clear error, which there is none here. So that is actually the first issue that the estate raises, and essentially, was there sufficient support for the court's findings concerning the home health care aides? And the answer is yes. There was testimony in support of that. Dr. Warner did testify in support of that, and the judge relied on his testimony and was entitled to rely on that testimony and credited that testimony. I do acknowledge that in our brief we did make a mistake in terms of recounting the evidence concerning the left hand mobility. This is 1581 of the trial transcripts. There was an acknowledgement that the left hand could not move.
The left hand what?
Cannot move. And that's 1581 of the trial transcript appendix.
Counselor, what's left in the estate after the taxes are paid?
That's a very good question, and that's not information that I have that I can present to the court. It's not something that was in the trial record as I was reviewing it, so I don't have that information. I suspect that because of the lengthy delay in this case, in the resolution of this case, that there may not be much left. I don't know for certain. That would require additional litigation, most likely in New Jersey, to resolve those issues. Perhaps I'm jumping a little out of order, but I would like to address that delay a bit, and this relates to the appeals bond issue. Now, this is a very deep challenge for this court and I think for the trial court as well. How do you deal with a party who refuses to honor the judgment of the court, who does not ask for a stay of the execution of the judgment, who leaves the Commonwealth, who...
Well, usually we let the probate court hold them in contempt.
And in this case, the probate court did find them in contempt. I think there's some dispute perhaps over what the status is of that contempt judgment because there was notice of appeal filed related to that prior to this case, in fact, much prior. This was before, I believe, the previous decision by this court. But in that previous appeal, there was no decision made concerning the contempt judgment, and there does not appear in the record any effort to satisfy that, whether on appeal or not, that previous contempt judgment. And so what I mean in explaining all of this is that contempt does not suffice, right? A contempt judgment did not move the husband or the estate to take any action. And so instead we have this case which is dragged on again for much, much longer than it really should have or needed to have. In the meantime, all to the benefit of the husband and now his estate, where he can continue spending whatever amount that he deemed appropriate for himself, meanwhile ignoring both what he had promised Ms. Vellis, but also what the court had ordered. And so we are now left in this circumstance where what can we do to facilitate the conclusion of this litigation? And again, I feel strongly on the merits, which my brief lays out, but concerning the appeals bond too. This court has the power to require the imposition of an appeals bond. It has the power to dismiss an appeal if that is not paid. The trial court did make findings related to that, and this court can affirm that.
How do we have the power to issue an appeal bond? I see we can dismiss a case if we find he's a fugitive. That's what Yusuf versus Yusuf says. Without a stay, I don't know how we could issue an appeal bond.
Well, I think that it was incumbent if the estate wanted a stay to ask for one. The status is essentially that the court ordered him to pay, and he did not. If he wants to avoid the responsibility of paying, then you should ask the court for that stay. And so this, again, has dragged on long enough where he has not done so. Therefore, it would be appropriate for this court to issue an order related to that now. Again, the court does not necessarily have to reach that issue because on the merits, if we prevail, then the appeal is concluded, again, absent additional...
It's moot, isn't it? Why is it not moot?
It would... You're right, Your Honor. It would be moot if the court agrees with us on the merits, with the one possible exception being that there may be a distinction that I haven't thought through yet concerning further appellate review, if there's a distinction between the court dismissing versus the court affirming the judgment and deeming
If we dismiss, they can still ask for FAR, as long as we dismiss. So,
again, I haven't thought through the entire issue yet, but you're right. I believe that it would most likely be moot if the court agrees with us on the merits.
And is there a reason that the trial court didn't pull the trigger on this at a point and just say, appeals dismissed, no bond posted? Is there any authority to do that?
I'm not sure I understand the question. Is the question, why did the trial court not dismiss the case?
Yes, but why did it, if the appeal bond never got posted, then is the court without any power to do anything?
My reading of the case law is that it may be without the power to do so because the case has already been entered in the appeals court. Then the jurisdiction then rests in the appeals court to dismiss the appeal, as opposed to the trial court dismissing the appeal. And that's why, you know, we explain that to the extent that the trial court has made findings, if they lack jurisdiction to make those findings, that this court can adopt them as indicative rulings, as analogous to what the federal courts may do. So that's why the delay has been such a problem. And I think the rest of this case is really just a symptom of, it's possible to read these issues now raised on appeal by the estate as evidence of weak arguments, perhaps intended, again, not necessarily intended, but perhaps intended to draw this out further. For example, if we're looking at whether the trial court was allowed to consider Dr. Warner's testimony and whether the court should have credited it or not, the trial court is obviously allowed to credit the testimony. The preliminary question, so this is, I guess, the second argument in the appellant's brief, concerns qualifications. And Your Honors asked questions that I think really strike at the heart of it. Under the expert standards, particularly the issue that was raised in the trial court, whether he had formal training, the answer is he doesn't actually need so-called formal training, he just needs to be qualified. And in fact, he does have formal training. He had medical school training and other trainings that did touch upon the question of insurance. But as Your Honors had mentioned, he also was a healthcare fraud investigator that obviously considered a lot of different cases. And healthcare fraud very much is a question of the money related to claims that are performed or are requested payment for. So absolutely, he did have the qualifications. The judge performed the judge's function in allowing and admitting that testimony. The weight of that testimony is then the fact finder's role to weigh. And so the real concern that the state shows is about how the court credited that testimony or weighed that evidence as opposed to whether it was properly admitted or not. Whether it's properly admitted or not is something this court should consider, but how it should be credited is something that the trial court should consider uniquely. Concerning the scope, and this is the third argument raised in the husband's brief, whether it was an abuse of discretion to exclude various witnesses from testifying. This is a little hard for us to consider at this point because it's hard to tell exactly what they wanted to put in and what was actually excluded because from my reading, it's hard to tell what was proffered and what that was supposed to show as opposed to what they did already actually put in and what the court considered. So this is a question of failure to preserve. We can also think of it in terms of harmless error, right? Because if we're talking about the scope of the trial being, what are reasonable medical expenses, obviously his medical condition, evidence of that came in. There were medical records that came in. And, the court considered all of that. The expert considered all of that. Both experts considered all of that. And they can properly rely on those in forming their opinions. So, again, from our perspective, it's hard to argue on this point because there's not much to argue because it hasn't been preserved, because it's harmless. There's obviously additional issues that I can address. I will point out that Any issues raised for the first time in the reply brief, this court need not consider, and we would ask the court not to consider them. And if there's any further questions, I'm happy to answer them.
No, thank you very much. Thank you both. I'd like to thank all the attorneys that appeared in front of us today. I'd like to thank our court officer. I'd like to thank our timekeeper, keeping the clocks running. And of course, as always, I'd like to thank the clerk's office that enables everything we do. And with all that being said, court will stand adjourned until 50 minutes from now.